Hold on one second. Okay. And do you have these in there?
No, do I?
Yeah, okay. I think those are extra. So Nikki, for just before I start, so on the Zoom, is it just Michael or are there other people?
Michael's there along with attorney or engineer Tricia. And then Ryan Maxwell, who is.
And Don Bracken,
Right, yeah.
okay.
Those are like the panelists and we have 19 attendees.
And. Just one second. Leslie, Shashi's first name is Ron. John, sorry. Okay, so this is this script for remotely conducted and hybrid meetings. Open meetings. We're using Zoom for this meeting. Zoom has the capability to allow the public to participate in the meeting as an attendee. The chair can request that members of the public provide their names for purposes of keeping accurate minute meetings. Attendees must register to participate. The registration link is unique to the meeting. The registration link can be found in the description of the Nantucket Government TV YouTube live feed for the meeting. Attendees will join in listening mode. They can click the raise hand button if they wish to speak. And that's only for the other. For Surfside Crossing, the plan review. The clicking and raising your hand is not an option. I will call on those who have raised hands in the order they were raised, and all questions should be directed through the chair. As a preliminary matter, my name is Susan McCarthy, and I serve as the chair of the Board of Appeals. Permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Lisa Botticelli. Here. Elisa Allen. Here. Michael O'Mara.
Here.
John Brescher.
Here.
Mark Poor.
Here.
And Jim Mondani.
Here.
Staff, when I call your name, please respond in the affirmative. Leslie Snell. Here. Nikki Sharrett. Here. William Saad.
Here.
And George Pucci, KP Law Town Council. Anticipated speakers on the agenda, please respond in the affirmative. John Cheshire.
Here.
And Ryan Maxwell.
Here.
Okay. Are there any other speakers anticipated that I didn't call? No.
Madam Chair, Steve Cohen has his hand raised since the meeting began. I'm not sure if it's
Okay.
something.
Okay, you want to,
Yeah,
it's just,
go ahead, Steve.
Oh, no, I was just waiting for my turn. I'm fine.
Oh,
Okay.
okay, I'll lower it then.
okay.
Madam Chair, I'd like to make a motion to amend the agenda for today.
Well, we're not done. Let me
Sure.
finish the instructions first. Okay. Good afternoon. This open meeting of Town of Nantucket Board of Appeals is being conducted remotely pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required in law. This meeting, the first matter on the agenda will not feature public comment. The first and second, and the remaining, if we get to them, will have public comment. For this meeting, the Board of Appeals is convening in person and by video conference using the Zoom app as posted on the town's website, identifying how the public may join. Please note that this meeting is being recorded. Some attendees are participating by video conference. Be aware that other attendees and viewers may be able to see you. Do not screen share your computer. Anything that you broadcast may be captured by the recording. All supporting materials that have been provided the members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless I note otherwise. Next is the ground rules. Before we get to the agenda, please let me cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I will introduce each speaker on the agenda, or Nikki will introduce the speakers on the agenda if they're on Zoom. After they conclude their remarks, after they conclude their remarks, I will go down the line of members, inviting each by name to provide comment, questions, or motions. Please hold until your name is called. Further, please remember to mute your phone or computer when you are not speaking. Please remember to speak clearly and in a way that helps generate accurate minutes. For any response, please wait until I yield the floor to you and state your name before speaking. If members wish to engage in conversation with other members, please do so through the chair, taking care to identify yourself. That may be a little bit lax today with the plan review, but we'll see how that goes. For 4 items with public comment, which will be later in the meeting, after the members have spoken, I will afford public comment to those members of the public that have joined the meeting via Zoom or in person. Members of the public who wish to speak must state their names and be acknowledged by and speak through the chair. Finally, each vote taken in this meeting will be conducted by roll call vote. Okay, so turning to the agenda as amended, Jim,
Madam
you're
Chair.
going to make a motion, I know.
Yeah, I'd like to make a motion to amend it to include a discussion of special counsel related to Surfside Cross. And I'd like to make that agenda item first on our agenda because of the pending hearing today.
So you're asking it to go, it would be a new number 4, number 4 would be number 5, and the rest would be bumped down.
A new what?
Well, the first one's called to order, approval of the agenda, approval of the minutes, so we do those 3 and then proceed to do
Yes.
your. It does need a second, but I actually want to ask staff, can we add that agenda if it's not been noticed?
Well, to add an agenda item that's not posted 48 hours in advance, it would have to be something the chairwoman didn't anticipate, and it would need to be something like emergency in nature. So,
And not or.
I mean, typically when you add something that's on the agenda less than 48 hours in advance, it needs to be something that can't wait until your next meeting.
Can I get a second?
Second, third.
Can I comment, Madam Chair?
Well, hold on, I'm just trying to think about the standard here. So you want to have this, you want to have a discussion in open session. No, there wouldn't be public comment. I just want to make sure, like, is it town council, do you have an opinion on being allowed to do that? I just don't want to, I understand there is a necessity towards discussing it now before we discuss plans, if we're going to discuss it.
Yes, good afternoon, Madam Chair, members of the board. George Pucci from KP Law. I have nothing further to add about it other than what Leslie said. If it wasn't noticed within 48 hours, you had to not reasonably anticipate it, and there also has to be some type of emergency reason to add it to the agenda. Because you always want to err on the side of having things properly noticed on the agenda.
Yeah.
So
Why didn't you notice? Why didn't you bring this up earlier?
I think in looking how this was all has been addressed, we haven't had the chance to meet. We're not allowed to meet. We've been in the dark on this, except for that meeting. And all I'm asking for is to participate in the litigation in which technically we are still a party to. That's occurring at 2 o'clock today. And I think that meets the emergency order of this.
But I think that it might meet, it might meet the emergency thing, but why, I don't understand why this wasn't brought to staff's attention to notice it earlier.
I'm not sure. I mean, I have the same question about the executive session that should have been noticed correctly 2 weeks ago. So the other part of this, to view things within the context of open meeting in general is good. But if we violate it and we're deemed to violate it, we can ratify it. There needs to be a complaint about it. So just if it's determined that there was a violation, it doesn't mean we can't proceed. That combined with the fact that this is an emergency. This is something that is occurring today. And I feel like we need to appoint counsel to represent us. And that's why I'm asking for this amendment to the agenda.
And there's a hearing today at 2 o'clock.
Correct. And we have no counsel.
I'm trying to think how to put this. We are under the town of Nantucket. The town of Nantucket has decided to not pursue litigation. So I don't see how we are still a party.
Well, this merely carries out the vote of this board, which was unanimous at the last meeting, which was to ask them to not file with the withdrawal. I think we were pretty clear about that.
But they didn't have to, but they don't answer to us.
And we don't answer to them, is my opinion. And I think it's not just me, but I think other members of the board might feel that way. And it is being done under some questionable circumstances, questionable authority of the select board, questionable vote of the select board. It does not appear that there was a majority based on the agenda or based on the minutes.
Okay, so we're
But
getting into
that's
discussing this now. So
well, I guess I'm saying there is an emergency need for this board to be represented. If it chooses, I'm just asking for the agenda item to be added.
Madam Chair,
yes,
I just want to note, I've already spoken to, my opinion about amending the agenda. I just have to clear up the misconception that there was anything improper about the select board's vote or notice of executive session. They duly noticed their meeting in executive session and the vote was 3-2. And there was no issue about the vote at all. So I just want to clear that up. That's just a matter of fact, not opinion.
I know we're not discussing it, but can I make a public comment?
no.
No.
There's no public comment. So
There's a motion with it and it's been
In a
seconded.
second.
it's up to me to decide. Or because there's a motion and seconded, we go forward. Okay, so I'll go down a roll call. Lisa, we'll start with you.
I'm in favor.
Elisa,
Aye.
Michael O'Mara,
Nay.
John Brusher,
Aye. Oh, aye.
Mark Poor.
I'm gonna abstain.
Okay. All right. I don't think you should extend, should.
Okay. Based on my lack of participation, I'm gonna vote no.
Jim Mondani
Aye.
and myself, nay. So what does that leave us with?
I
What did
don't,
the-
we're a 5-member board.
Right. Why did we have
I just-
everybody vote?
Because I just wanted to see, I did
That,
it.
that,
No,
that doesn't,
that doesn't work that way.
right.
Madam Chair,
No,
Okay,
it's 4-3.
fine.
It's 4-3, so it does work. We carry.
So then if you guys don't want to do it, it'll be Lisa, me and Jim, because we sat on it. Mark, you're saying you don't have any participation. And we'll do,
Elisa and John. Michael didn't sit on it either.
Elisa and John. Michael and Elisa. So that means it is 3-2. That carries.
Okay.
All right, so Jim.
Madam Chair,
Mhm.
I'd like to make the motion to approve Peter Finn as special counsel to represent this board in connection to the appeal that's occurring, or a hearing that's occurring at 2:00 and going forward.
We have no authority to, correct me if I'm wrong, staff or town council. I do not believe that we have authority to directly hire counsel. I don't know who is going to pay for that counsel to go to that hearing. And the select board is our appointing authority. They are the executive branch of our government here in the town of Nantucket, and they have the authority to determine, first of all, to give us access to counsel and to determine how litigation is, the process for the litigation. So I don't see a path to us hiring outside counsel. I don't see how that, and perhaps I'm incorrect in that, but I don't, if this gentleman is going to go and represent the town of Nantucket Zoning Board of Appeals, who is he billing? Who has authorized him to represent?
We will get a engagement letter from him. The attorney is willing to deal with payment at a later date. I don't think that should hold up anything. George is not our lawyer. George is a town attorney, but he cannot serve two masters. And right now that's what he's doing. George represented us up until, say, a week ago, and now is going against us on the basis that we're all one, which we normally are. But we're two boards now in conflict of how this proceeds. And we don't even need to talk about our position on that. We voted on that. We asked George to not file things until we had, it was conditioned upon getting a list of conditions that we found acceptable. I don't really want to go into that. I feel the board should be able to vote on my motion. And you as chair can facilitate it, and you as chair can have your opinion, but you can't prevent the will of the board.
No, I'm asking the question of, even if we vote and say, if everybody votes and says, yes, we should hire counsel, I'm asking the question. I don't see a path to how that is viable. I'm not saying I'm not blocking your motion. I'm saying I don't understand how that's even.
As feasible. Background, we don't have an attorney. I attempted to file documents that really backed up what the board expressed in that meeting, and was not able to because George is the listed attorney for this matter. And it's a purely procedural matter. We need an attorney to go to court to represent our view. We're in a pickle, and this is not like it's unplanned. This is clearly what we're trying to do.
Okay, we asked the select board, we asked George to send a letter, and he said he would send an email because he had been instructed to file directly after the meeting. And he sent an email to myself and Libby, which was, I assume, sent to the select board. The select board declined our request. So, and I don't think, actually, I know it was not appropriate for you to file or attempt to file anything on behalf of the board, just like it was inappropriate to speak to the reporter on behalf of the board as a board member when you do not speak for the board speaks as one voice. So that was a big overstep. And then trying to post a meeting was also a big overstep. So again, we can have a motion to hire this special counsel and to have this attorney appear. I just don't see that we have the authority to do so.
Can I just make a comment?
Sure.
I feel that, and I was just looking at my texts 10 months ago, the last time we actually were even brought to discuss this was with George in this building. And I have a text because I was texting with Ed to say, and I'm going to cry because he's not here. Can I come pick you up so you can come and discuss this? Because this was an important application for you. And George sat here and said, you guys should definitely file this appeal. You know, you have good reason to, and both, you know, he just went through the process. That's the last time as a board we ever talked about this. And then to get that email when I was on vacation about this executive session about this with all these conditions that were made, it just doesn't seem right. So I don't think we've been treated as a board or heard as a board. You know, I didn't agree with any of those conditions, and we were the ones that sat through that entire hearing process. So I don't understand why we can't have our voice heard in some fashion. It's, you know, and I don't understand why the town didn't come to us. And there was no discussion about this until that letter was dropped into our email box about the conditions that were met. I mean, that's just not how a town treats a board. So, you know, maybe we don't have any power, but I do want to go publicly on record. I think it was terribly mishandled. We were not given the opportunity to discuss any of the conditions, some of which I completely disagree with. And so I do feel like we need counsel. It might not go anywhere, but for today, I think we need to have somebody that can represent the interests of whatever the majority of the board happens to be today. And it might not be to go forward. I don't know.
So are you, when you're talking about conditions, are you talking about that you felt that we should have been, and I agree, well, that meeting that we had on April 19th was.
I wasn't even part of that meeting because I couldn't be here. And, you know, and I also don't think that that's fair. You know, that it was like sprung on us 2 days before I was going on vacation.
No,
I mean, this isn't
that was poorly handled.
the whole
100%.
thing has been poorly handled.
That was poorly handled 100%. And the fact that we didn't have any information or the press release beforehand was very poorly handled. And I addressed that in the meeting because that was not right. I agree with that. I just have a question about the conditions and not being able to discuss them. Are you talking about in the lawsuit when Hack came, or the conditions that Hack came out with? Or are you talking about the conditions in the press, in the press release?
Yes, in the press release.
Okay, so my understanding of those conditions is, and again, I don't agree with this, but they're not, they're not, they're malleable. It's in process.
Right, but who's negotiating those conditions?
Right.
Why aren't we negotiating those conditions? It was our suit to fight.
Right, agreed.
Okay, so that's my.
Madam Chair, can we keep this to the motion that's on the table?
Sure.
And let me just make this point on that matter. This is no statement about anything. It's not a statement about affordable housing. It's not a statement about the developer. It's not really a statement on anything that will happen. We just need representation to at this hearing to withdraw that lawsuit on the basis that we no longer have counsel. He no longer represents us. And he has a serious conflict if he's going to represent us and the board. And this is classic conflict to sit here and say, I think you should appeal, and then suddenly come because he's talked to another group and say, I'm withdrawing this on someone on his other client's position is just wrong. And that is why we need special counsel. I don't want to get into any of the specifics to 40B. I just think that if we vote to have representation by another council, by special counsel in this hearing, we've made a statement on, and it's a continuation of what we asked George to do, which is not to file the withdrawal. That's all it is. It's not
Chair,
mine.
I don't mean.
It's
to
not
be
mine.
rude.
Can I continue?
But-
It's not my personal mission here. You have fellow board members who totally agree with me. And I don't think you can use this process to push out the majority of these board members that just want the appeal to remain on the docket with us as the main appellant until we have an agreement. We make this decision. We might meet an upcoming after this and decide we agree with the Board of Selectmen. I'm not making any statement of that. I'm just saying we make the decision. The 40B is the Board of Appeals, and we are independent boards. There's no hierarchy of boards. There's no, in our town charter, I do not see anything with a select board where it's specifically enumerated where the select board can decide to override all of the boards. Otherwise, why are we volunteering for these boards? When we let other boards make a decision on our behalf. There's even a question of select board who advised them. And my understanding is the housing board made the decision to ask the board to get out of the lawsuit. They're not even a member. They're not even a member of this lawsuit. And here we are sitting in the dark. Come on. Simple. Let's get independent counsel to advise us correctly on this.
I'm just going
That's
to
all I'm
clear up
asking.
a couple of things, Madam Chair, because I'm now listening to it and I'm trying to be polite, but I'm listening to it over and over again. I immediately conveyed the zoning board's vote to the select board. They declined to reconsider their decision. I set this all out in an email to Mr. Mandani last week, and I'm asking for that to become a public record and part of this proceeding. I was very clear and very respectful of the position that the board was not consulted before the select board voted to dismiss that lawsuit. So I want to be very clear about what went down, what the board asked me to do, what I did. I complied exactly as the board asked me to do. I don't have a conflict. I'm town council. I'm directed by the select board. The select board is the executive authority over litigation to which the town or a town board is a party. And the select board is not authorized continued litigation by the zoning board in this case. You can take the vote, and I said this at your last meeting when it was remote. You can take a vote on any motion that you want to. But I'm just advising you, as has been already advised to Mr. Mandani, that the zoning board does not have the ability to vote its own counsel and continue litigation that is not authorized by the select board as the executive authority. There is one exception in the town charter where the town is the plaintiff and the board is the defendant. In that case, the board has the right to vote its own counsel and have that counsel paid for out of the town council budget. But there's no conflict of interest. I've been very clear with the board about how the case was, how the vote went down with the select board, what I was advising the zoning board. And I reminded the member of the executive authority of the select board. And I'm not contradicting anybody factually about that they wanted to be consulted before the select board voted. I'm not part of that decision. I'm not a select board member. I'm only counsel coming to convey what the select board voted. But to the extent that anybody's trying to, raise some type of improper conduct or conflict of interest, all of that is just simply not true. Now, I would be very surprised if Mr. Fenn is going to court this afternoon and representing that he represents the Zoning Board of Appeals, since this is the first time you've met as a quorum in a duly noticed public meeting. And Mr. Fenn is well aware of Nantucket bylaws and charter provisions and is well aware of the executive authority of the select board. So I just want to note that. And again, I'm not telling you not to take the vote. You can take the vote.
And George, I want to just say, I wasn't saying voicing my displeasure against you in terms of not hearing about this. I was just making the statement that the last time we did talk about this case, you were here representing that the hack decision had come through. And I don't know why that is, and I'm not saying it was necessarily your prerogative to bring it to us, that these other discussions were going on, but that is actually the last time I believe we were brought any information about Surfside Crossing was 10
Right,
months ago.
that was authorized, Lisa,
Right.
because it was a 30-day deadline to file it.
Right.
And we wanted to make sure we communicated with Plus that could get before you so that you could vote.
Right, I
And I want to be
understand.
clear, I'm not telling you you don't have a leg to stand on in the lawsuit. I filed the lawsuit and I had to sign off on it as an attorney. There was a good faith basis for the lawsuit. So there's no debate over the merits of the lawsuit. But there's also no debate over the executive authority of the select board. And so that's the only thing I'm just trying to make clear to the board respectfully. And, again, you can make the motion, you can make the vote, but, the law is pretty clear about the executive authority of the select board. And there's also case law in Massachusetts that a town needs to speak with one voice in litigation, and that has to come through the executive authority. Which is typically the select board in a town.
George, something you said just made me think of this, and Lisa, what you said, we haven't heard from the Board of Selectmen, but they are willing to speak with us and have some kind of joint meeting. And Libby had asked me about that over email, and it was my plan today to bring that up and see if we're interested still in doing that, because that was something that was discussed at the April 19th meeting.
I think we can talk about all these things. I just think we need to get representation in this hearing and to keep the lawsuit intact until we talk about all these issues. This all could have been done 2 weeks ago. And you're telling me now they're willing to do it?
Yeah.
The filing should have been held up. We had the 2-day time frame for filing an agenda, gave us plenty of time to deal with this. There was no sense of urgency, which makes me skeptical of this.
Well,
And I just think that the board, and if you think the board has the right to decide whether to pursue it. We entered into this litigation, not the select board. And that's important too. We made the decision in our executive session to enter into it. I can't see where there's any question that this board shouldn't have the ability to do this. And this is very unique. This is very unique. It's very troubling. I don't want to pit, fellow members against each other. I just say simply, let's not cancel this case. Let's appoint a special counsel, did not cancel this case and carry out our directive from 2 weeks ago. That's not even up for a motion. The motion is to obtain special counsel to represent us and file a withdrawal of the withdrawal, essentially.
Just to note
hold
that
on. Can I say something first?
Yeah.
I want to ask you a question, George. Can you just clarify that, yes, we voted to appeal, but that was because we were authorized by the Board of Select, or the Select Board rather, to have the option to appeal.
You made the vote in executive session and you voted to hold off until the select board had a chance to meet and authorize the appeal. And the select board, that was the only thing I was just going to point out to you. You did vote, I was here, you voted to appeal the ruling, but hold off until you would check with the select board.
Well,
Recognizing as you do, if I can finish, recognizing as you did, and I presume you still do, that the select board has to authorize litigation. And you voted that subject to the select board authorizing it, and the select board did authorize the litigation, and that's why we filed it.
And I also just want to,
What is the
I-
point of executive
Hold on,
session,
Jim.
George, if you're talking
Jim.
about the vote in that meeting? You're talking about what we discussed in an executive session, which I don't recall, but we can go through it.
The vote, I didn't discuss anything about it that was protected by the attorney.
You discussed the specific
The
vote.
vote was public.
I don't want to get back into back and forth with George about this. I just want to be clear. My line of questioning, am I trying to think this through, and my vote against allowing this motion that we're discussing right now to discuss this. Sorry. It's not, it has nothing, like Jim said, it has nothing to do with Surfside Crossing, affordable housing, or anything. It's just process. And
Right.
what I think the process is. So whether this was, whatever the merits of the lawsuit are, or that is not what we're talking about now. And I just want to be clear about that.
Right.
So, I mean, I sat through those meetings, with
yeah.
you and Jim, and
Jim.
we spent a lot of time. I mean, these are all my notes that I saved, and this came back so that I would be able to look at what came out and double check and make sure that everything that we wanted or that we hoped for, like how it was in and all that. So this was a huge project for all of us and a huge undertaking. It does not feel great the way that it came down, and it does not feel great, but I don't see a path of how we have this other attorney. What I see our job as, and why I will vote against this motion, is that we have these conditions. What HAC issued is before us. We have the opportunity to go through all the conditions, compare them with what we did, all of us together, and make the best out of this project that we can for the town. And that's where,
And what was the select board suggesting we meet about?
just to talk about, just Dawn Holgate has been very forthcoming, saying that, she agrees that it wasn't handled the best way, and that we should have been, but should have, that it isn't what happened. And unfortunately, it happened the way it did. We are where we are.
So why not? Why wouldn't the select board be open to keeping the lawsuit open just until we were able to have a meeting with them? I mean,
I
that seems like a fair request.
I don't know, but you can ask them if we have a meeting with them. But at this
But
point,
we
the
won't be able to
decision's
have a
already-
meeting with,
The decision's already been made, so.
Well-
Just to comment on that, Lisa, it's not just happenstance, the way this all happened. And, for the select board to say, oh, I didn't know. Oh, we filed the wrong agenda. There's too many things in play. So I'll just suggest that it wasn't happenstance, and it didn't just happen the way it did. And you need to look at it that way. If you think, things were in play long before this,
Well, I think.
because we
yeah.
should have been consulted beforehand.
I
Thank you.
frankly don't even remember being told that they filed the lawsuit.
Same.
I don't think that was it ever came back to us that we were in fact in a lawsuit, that we had appealed this. I knew, the Tipping Point had and the Land Council had, but I don't think we were ever told that we were a part of a lawsuit.
Well,
We always copy the department in charge of the board.
Well, I'm not so sure that, I'm not so sure that we were, as a board, were told.
okay, so maybe that's on me. I don't know. I mean, I definitely saw filings here and there. I knew it was chugging along. But we never asked staff for an update.
I just
don't
assumed
think
that
there
that we would be given an
But
update.
I don't think there was anything, I don't think there was anything momentous happening. I mean, it was just,
Well, at some point there was. And we were never.
well, at some point
consulted.
obviously there were
Discussions happening.
discussions
that we
to
weren't,
come- Right,
right,
exactly, which we
right.
weren't included in.
exactly.
But that's when we should have been interfacing with the select board. Not now running after the bus that's already left the station,
It's just,
Yeah, I agree.
it's not right. So I don't know why. Well, I think we should just take Jim's motion to a vote and see
Yep.
what happens. I mean, and whether or not the select board will fund his appearance today, or whether or not he'll even be able to make that appearance at the court hearing, I'm not sure. But I think we should take a vote on it to show where the board stands on the issue.
And the
Fair enough.
the special counsel has indicated, not that we need to go into this, that he will do this pro bono if there are funding issues, but that shouldn't be considered when taking this.
Okay, so Jim made a motion. I don't think anyone seconded. Oh, sorry.
Madam
Leslie.
Chair, I think this was said already, but the select board has to vote to allow you to have your own counsel. It's not just a matter of them approving the funding. They have to vote to allow you to use someone different. So there's no way that's going to happen for a hearing today at 2:00. Judge.
Information. Sorry. If it helps today too, the hearing today is a motion by land council and the tipping point to introduce additional evidence in the HAC proceeding. So you weren't a moving party in that anyway. I don't know. I just want to be clear about the hearing. That's not a dispositive motion or anything like that.
Well, then that would be all the more reason for you not to file our removal so soon. Because it's just a hearing.
Sir,
You're kind
I
of going
sent-
back and forth. And this is the problem. You're
but hold on.
conflicted.
You can't say
You
you're
are
going back and forth
conflicted.
and you keep repeating it. You made a vote. The vote was to tell the select board that you wanted to be part of the negotiation on the settlement agreement. And then the second part of the vote was to ask them not to withdraw the lawsuit until you had met with them. And or until there was a settlement agreement. They
Attorney,
declined your
you
request.
have a duty
So you
to
don't tell me
listen
that
to
you
this
told
board.
me
Guys,
to not
we're-
withdraw the lawsuit.
We're
We
not,
don't
That was
work
not the
for
vote.
you.
Jim
You
and
work for
George,
us.
we are
No,
not
that
going to
was
get into
not
a
the
fight
vote,
right now.
Jim.
Both of you stand down and stop.
So listen,
Jim,
knowing this,
Jim.
he should have waited and suggested a special meeting before filing this because it's only a hearing.
Jim,
And
you and I are both attorneys, so we know what George's role is. Stop. Look. you
And
have
let me
your-
just say, George did a great job, has done a great job representing us. This is not personal. I just don't agree with his approach within the past 3 weeks. That's all. George has done a great job representing us. And I've totally been supportive of George. I just want to get that out.
Okay.
I just want to be clear, Susan, I don't do things on my own. I don't appear for hearings because I feel like it or because I want to represent the board. I only can do something as town council that's authorized by the select board.
Right, today
And
you
the
were
select
authorized to
board
come.
Did not reconsider their vote. They did not tell me, do not go forward with the dismissal. We want to meet with the zoning board first. Of course, if they had told me that,
Right.
I wouldn't have filed the withdrawal. And there's been a passage of time since they've known about this, and there hasn't been a reconsideration. So again, I'm very surprised that Mr. Fenn would go to court today representing that he represents the zoning board of appeals.
Yeah, I don't think anyone, and I don't think anyone or the public as well, no one thinks that you would act on your own and either not file or file without directive from from the municipality.
But just to be clear, he had two differing views on this and immediately filed it. If you represent us,
Jim.
then you should tell the board and hold off till we could meet on it, which was 2 days after that.
He did.
We had 2 days to notice a meeting and have it. And clearly things were in place. Things are in motion. We know it. Let's not play games as if, oh, it's just happenstance and meetings weren't called correctly because.
Okay, Jim, you said before you just want to focus on your motion, so we're not going to talk about
Okay.
what ifs and whatever.
Well, the background's important. That's all.
Okay, so you have made the motion. I don't
I'll
have a
second it.
second. Okay, Lisa has seconded.
Madam Chair,
Yes, Michael.
I just have a couple of comments.
Okay.
I had the great fortune of joining this board 30 some odd years ago. And the first time we had a suit that went from hack or the courts to selectmen, I think everyone on the board was surprised. And everyone on the board was there at the pleasure of the selectmen, and everyone started as a member fresh the same day. And we were surprised, but the fact of the matter is that this is not unusual for the selectmen to make a decision on litigation that comes back to the island where the judge has given the town some orders. When I first got on the zoning board, there were 65 lawsuits, and the 3-member zoning board had been fired by the selectmen, and they wanted to make it a larger zoning board of appeals with some different opinions, and took a long time to get rid of those lawsuits. I think there's probably still one that's somewhat active, but as far as calling this standard operating procedure, I would say it's exactly that. Do I like the process? No, I don't, but I think everything was done correctly.
Okay, thank you, Michael. Yes,
I'm not sure if you're taking public comment. I don't think so, but I have Attorney Finn's hands raised along with Attorney Haverty, who represents the 40B Feely.
well, I don't think it's appropriate at this time to have I don't think it's appropriate to have either of them talk
Okay.
at this point. Is there, do you think any, Leslie or George, any negative repercussions from not allowing other people who aren't involved to talk? Like,
asking to speak, I would love to speak.
you mean to let Attorney Fenn?
What? I'm on hold.
Well, if you guys,
Because
if we're,
that'll open up the room for everybody to speak.
well, if we're voting to, essentially voting to hire this speaker, does anyone want to ask him any questions before a positive vote comes through to hire him?
Madam Chair, just a quick question. Can we vote to hire anyone, or do we have to ask the select board to hire them? I was under the impression that even if we make the motion, we can't hire him. And as a procedurally, we have to ask the select board to allow us to engage in outside counsel.
I think that's correct.
Right.
Yeah, I just wanted to say that that's correct, in my opinion. And again, I'm not trying to obstruct you from making him, I did agree with Leslie that really it wasn't a proper motion because it wasn't noticed on the agenda. But now that you're into the discussion, that's exactly right. That's my opinion, that you don't have the jurisdiction to hire your own special counsel in the Surfside Crossing litigation without select board authorization. And you're free to accept or reject that opinion, but that's my opinion. So if you go ahead and vote it, in my opinion, it's not effective unless and until you get authorization from the select board.
I mean, I think I understand that. But
But
I still think it makes sense to vote on the motion because I think it shows
yeah, I think
the character.
So do you want to amend the motion, amend the motion then to change the language to request the ability to hire separate counsel from the select board?
But I think we need to meet
subsequent
with them
to our
before we just ask for
subsequent,
permission.
yeah, subsequent to our appointment in this meeting, we will request, if it's required, select board approval.
And you're saying you think we should meet with them first before we meet with select board before we go ahead and hire counsel?
Yes.
Yeah.
Because they're
But-
just going to turn us down if we don't meet.
These things don't need to be discussed. There's a important hearing at 3:00 tonight.
It's a chicken and the egg.
And if
Okay,
and in the same manner this has been handled by the town, we do things and then we look at
Okay.
whether it was correct or not.
Understood.
That's my point. So I The motion's on the table. I asked for your vote.
So Jim has made the motion to hire attorney Finn?
Yeah.
Hire attorney Finn to represent the zoning board of appeals. And subject to the select board's approval.
Right.
Okay,
Subsequent to his representation, because it's just not, we all know it's not it's not going to practically happen.
Before 3 o'clock
And-
today.
Right.
Yeah.
and
And obtain the blessing of the select board.
Or
after-
the decline.
or decline after representation. The circumstances are too unique here to follow the procedure. We've been jammed up on this. And I think we should proceed with this and deal with all these other questions after the fact.
Excuse me, Madam Chair, just to clarify, you have 5 full members present. None of them have identified a conflict. You entertained a motion by alternate member Mandani. Who are your voting members when you take this vote?
so. If Jim has made the motion, does he vote? Because normally it would be the full members would vote before alternate, correct?
But he said.
But he sat on the,
On the SURFSIDE
On the
project,
SURFSIDE,
and
yeah.
Marvel did it. Yes.
right, but as we said, this is procedure. We're not voting about Surfside Crossing.
I would suggest you
But
get the vote of the regular board members. If that's your concern.
well, and Mark, you're an alternate, okay. So.
To avoid perception that members are chosen.
Okay,
uh,
that makes sense. Thank you, Leslie, for bringing that up. Okay, so Jim has made the motion, Lisa has seconded, and I will then just do a roll call.
Can we have discussion on the motion?
Yeah, sure.
I'm not inclined to vote in favor of this motion for a very simple reason that I think procedurally, we do have to ask for the select board. I think what Jim had called for originally, as sort of painful as this may have been for delaying this for an hour, I think it was good. I think we need to air these grievances. I think it's a wise idea to have the select board because at the end of the day, I think this has been a poor process on their part. And I don't think that we should continue with a poor process. And so I would be in favor of voting to request the select board that we hire outside counsel, but not just hiring him.
Okay.
That's just
Not just
my
one.
not just hiring him.
And if this is
It's just my 2 cents.
Where is the authority for that? Since you are swayed, I'm not asking you. By that. The authority of the requirement that the select board. Pre-approve any special counsel.
It seems like it's,
It just is, right?
no,
It's-
that's not what I was gonna
it's in
say.
the town charter.
Okay, it's in the
And
charter.
can you read that, please?
It's in the charter and it's in, I don't have the charter, but it's in the charter and it's in, and it was case law, right? That we can't be. The town has to speak as one.
You're making things up now.
No, I'm not. We just talked about the case law that the town has to act in one voice. You can't have two different.
That's case law, but your local charter and regulations are very clear about what I just said about select board authority and the exception when the town board is the defendant in a lawsuit brought by the town. I don't have the ability to read it to you because this was not noticed on your agenda. And the folder that I have for this meeting is technical compliance with the final plans. And so whatever you do today, I would recommend very strongly you get to the item that was on your agenda because that's serious technical issues. You get a professional engineer on the line to make sure that the developer is complying with the conditions of approval as amended by the Housing Appeals Committee. So whatever you do on this unnoticed show, do it, and please get to the agenda.
I don't think you should characterize it as a show
Well,
in that
Jim, this
disparaging.
Jim-
There's no show
Jim,
here.
enough. This is getting out of control.
Oh.
And if you are so concerned, if you, like, you're saying I'm making things up, did you bring the charter to show where it says that we have the authority to do this?
I'm alleging that it's not in
Okay.
its charter.
All right, well, we're not talking
So-
about
Well,
alleging, so.
this is relates to someone voting on this, so.
Okay, well. John, are you willing to amend the motion, Jim?
No.
Okay, so the motion stands to hire counsel subs with the select board's subsequent approval. Is that, or how do you want?
Yes.
Okay, okay, we'll just do a roll call then. Myself, no. Lisa,
Aye.
Elisa,
Aye.
Michael,
No,
I'm sorry, what?
no.
And John.
No.
So that does not carry. Okay, we're gonna move on to Surfside Crossing, final site plan engineering review and review of conditions. So does everybody have?
Excuse me, before we move on, when do we get to discuss when we're going to be meeting with the select board about this?
I will, through staff email, or Leslie will email Libby and we'll see what we can get on the books.
Will that be a closed meeting or open?
I don't know at this point what it will be. We'll have to see how it can be structured, what the topic will be and what the requirements are.
And is everything in full motion as is until we have that meeting? With the
Yeah,
withdrawing of the
yeah.
lawsuit and,
Yes. The lawsuit has been dismissed for the town of Nantucket, and the town of Nantucket is no longer in the lawsuit. The time is ticking. Today at 4:30, we're out of here, hard stop. The time is ticking for us to have any impact on any of these conditions that are not not what we want, but that are not what is on the plans or what the developer is planning to do. So that, I think, should be our number one priority. I think it's important, like John said, we had the conversation, people were able to air some grievances, but we need to focus and look at this very, very carefully. So that we can do the job that we started and worked so hard on during the application process. So, I was thinking that we would just have our engineer go through the conditions with us and people can ask questions, and that they have on each condition. Everybody should have. Does everyone have copies of the May 3rd? It's pretty long, like 40 something page thing, and then also the 16-page highlighted document that we got a couple days ago. Yes. Okay, so then I'm gonna turn the floor over to our engineer to go through these for us. On Zoom, right, Nikki?
Yeah.
Yeah.
Okay,
John?
you ready
Oh,
for me? So obviously, we know this is a pretty complicated project and it was pretty complicated going through your decision, the HAC decision, compiling all the information into one sort of document with comments. And then as you know, it's an extremely long document. So I did do a summary, which is still a long document compared to a typical review project for me, but many of the conditions really don't require a lot of comment, and I think the best way to do it is to sort of go through those. I have my summary and I have the full letter in the computer and I got all the decisions here, but if that pleases the board, would that make sense to sort of start with the summary and sort of list the condition numbers, and if you can follow along, and if they're quick, didn't change, was slight modification, we go there. I did try to highlight in the summary sheet that I did, the ones that may require or the board may want to discuss or talk more about, but I don't know, does that make sense to the board?
Yeah. Does anyone have a different view on how we should do this?
Yeah, so if there's the one we want to discuss and he goes over it, we can go. back.
Yeah, of course. Yep.
Okay. Well, I'll get started. I know it seems like a long time, but there's a lot to go through, so I'm not sure we're going to get everything, but we will try. So the first part is eligibility. The HAC modified condition number 1 slightly, and the other 2 had no change. I don't think there's much to discuss there. The next 12 conditions are the general conditions, and the only changes from HAC, there was a modification to allow the permit to be transferred with, they changed the condition slightly, and I actually couldn't even see where they changed it, but they claimed they did, and it looked like it read the same to me, but anyway. And then condition 10, the reference would go to what was called Exhibit 3 in the HAC case, which was the plans that are dated February 28th, 2020. So that's the plans that the HAC used in their decision. Subsequent to that, what was submitted to me was a set of plans that are last revised March 30th, 2023. And some of those changes are highlighted as I go through this letter. If anybody has a question in the meanwhile, just,
Can you just repeat that last part again?
Yep.
About
Okay.
What the dates were?
Okay, so the dates were, the HAC reviewed plans that were revised February 28, 2020. I'm looking at them on my floor. I've got stuff spread out all over here. So the permitting set was originally dated February 15th, 2018. And it was revised through February 28th, 2020. That's what's called Exhibit 3 in the HAC decision. And that was the set of plans that they based their decision upon.
Okay.
Right, which was different from what we saw when it came through us.
Quite a bit different, yes.
Yes, okay. Can I have a question on some of the
hold
general
on.
conditions?
But no, hold on. But then the plans, so the plans referenced in the HAC decision are the 2/28/20 plans,
Yes,
but the
Yes.
decision, but the plans, what's the date on the plans that the developer submitted for our review?
2/15/18, I think is what you said, right, John?
No,
So that's
the
the-
current plans, so the current set of plans that were submitted is dated or revised March 30, 2023.
Okay, that's the date I was looking for. Okay, so
Right.
that will, okay, thank you.
And there's also, there were some other supplemental things. I listed them all. And we may get into that. There was a fairly large set of landscape plans.
Mhm.
Those are dated March 31st, 2023. And I think that those landscape plans and some of the other, the March 30 plans were in response to the HAC decision to some extent. So
Okay,
I had to compare the two because the decision referenced the 2020 plans. And the new plans are 2023. So there are some changes.
so some of the conditions that I had questions about and wanted to discuss, it touches on this, because the plans, I just wasn't sure like which. Well, let's see, which is the one that we look at? Is it the number in or the plans that were done the 30th of March or the decision from HAC?
The plans that are submitted for you, I believe, are the March 30, 2023. Those are that's the current plan set.
I know, but that wasn't, I'm saying like the body of the decision, like, for example, when it says like 15A for maximum ground coverage, the condition wasn't struck, but the plans, the plans dated 3/30/23 have a footprint that's 3 times that size. So my feeling when I was reading through all of this was, okay, well, Hack said 1,000 feet was what it should be, because they didn't strike it. So the plan that's submitted now that we're reviewing should show 1,000 square feet, not 3,102 square feet.
Right, that's some of the stuff we,
3975.
right, that's some of the stuff we need to go through and clarify, right?
Right,
And
well, that's what
approve
I'm
or not
asking.
approve. Yeah,
Right, but that's what I'm asking. Do we?
we're approving it based on the fact that Hack didn't strike that.
I know, but what I'm saying is the hack has seen these. The plan, like, is it the plans or is it the decision, which is,
I'm going by the decision.
I am too, but I want to make sure that we're doing it correctly.
You have to use the decision, but you also have to look at the plans that were in the HAC proceeding.
Uh-huh.
So that's what you're comparing for the March plans.
So we don't have those plans, I don't
You
believe.
should. I thought Sean had that,
We had the
thought that-
330 plans.
Yeah.
but I
which we
think
don't-
John's analysis was comparing the plans from the proceeding to those final plans from March.
Yeah,
I don't think so. I think it was I think it was comparing the two decisions, right? Our comp permit and the hack issued decision.
It should do that, but you also absolutely have to have those plans. They were an exhibit in the PAC proceedings. You have to have those because
Right, but
those are the plans that they struck your 60-unit plan condition on.
right, do we have a small copy of those plans that were part of this decision?
I assumed you had them.
I did not bring paper copies, but they were posted online. They were part of the materials that you all were provided back in March or April. No one requested paper copies of those.
Well,
So-
I didn't know that they were different than what we requested paper copies of. It wasn't clear. So,
So,
Definitely need them.
okay,
I mean,
yeah, I mean, it was unclear to
but
me. that
those
they're
aren't
not-
the
they're not one
final-
of the same.
so I guess, yeah, me too, because those aren't the final plans. The final plans
You
are
haven't even
3.
gone to final
right, but
plans.
you can't judge compliance of the final plans unless you know what they're being compared to.
Right,
So you absolutely have to have those plans in front of you.
Right, but.
so
Okay.
maybe we can talk about some of the general conditions right now and some of the other stuff. And get copies of the plans that were part of the hack decision.
Right, so again, to me, I feel like if the plan that says is March 30th, 23 shows a clubhouse or whatever it is, that is anything greater than 1,000 square feet. That's not what that is in the hack decision. The final plan, any plan should show it at 1,000 square feet.
I
Correct?
agree.
Yeah,
I
okay,
agree,
correct.
but
Okay, all right, good, okay.
definitely need those plans though.
Okay, that makes sense.
So can I request a copy of those plans now?
Sure. And Madam Chair, the engineer who's doing the review does have those plans. He requested those
Yeah,
from Don Bracken in a format that would be easy for him to use to do the comparison.
Right.
So that is being done. That's not
Yeah,
something that's
no,
been
right.
overlooked. And then the other thing I just want to point out on the dates, because people may be wondering. The applicant submitted plans to our office on March 21st or 22nd, whatever that date was. And then they submitted a revised plan set that was a little better consolidated and reorganized with some minor tweaks. So that's where that March 30th, 31st date is coming from. But we did have plans prior to that.
okay. Okay, okay. All right, anyone else have any other questions about this at this time, or should we?
I had a couple
Okay,
general conditions questions. Number 4, it says evidence of final approval is a condition precedent to any grading, land disturbance, construction of any structure, infrastructure, or issuance of any building permit. And then the decision 8 also talks about there needing to be a regulatory agreement prior to any grading, land disturbance, construction of any structure, or infrastructure, or issuance of any building permit. Has that regulatory agreement been met?
Yeah, I had both those. same
And there
questions.
was disturbance of the site already without final approval. So that was one question that I had. How were they able to clear part of the site without final approval?
Did you have 1, 4, and 8, right? What was your question?
I didn't even,
Because number 1, I just.
I didn't have 1 circled, but I had
Yeah.
4 and 8 circled.
Yeah, same thing. So George, do you want to address?
Yeah,
that? Thank you.
I would agree with that, as Lisa just articulated it. I'm just wondering what your format is going to be. Are you going to keep records of what you've noted and notify the developer?
I think so.
So what I would recommend you do is somebody,
Elisa, you're the clerk, so get your notepad out, girlfriend.
Oh, thank God, I'm not. I would
Okay.
read my writing.
Just.
Do you want another copy of the, I might have I don't have a second copy of his, because you could just circle the items that we're questioning.
Okay,
Do you have?
hold on. Let me change my process.
Just because we don't have to write as much, maybe.
True.
Do you have another copy of this? You can just circle the ones that are in question.
I'll just take the numbers.
Okay, so it's on their eligibility. Susan, you had 1 circle?
1, 4, and 8. Is that this says, well, I guess we don't have, that one is just to keep a note of that before the building permit is issued, they have to execute the regulatory agreement.
Right, and that's number 8, right?
1, eligibility,
okay.
and then under general conditions 4 and 8.
Yeah, okay.
Okay.
So then.
And then what was your next? My next one was,
The recreational building was my next one.
Was, yeah.
15.
15A. Oh, actually, sorry, my next one was, so under 13, where it talks about the single,
I thought that whole section was stricken because none of this is applicable.
well, I don't,
But it's not all crossed out, but it says, I thought John wrote somewhere, it says. As the revised plans do not include any single family building lots, this entire section is. no longer
right, but they
applicable.
hadn't,
They didn't strike.
they
them
didn't
all.
strike it all, but it should just come out because there are no single family dwellings, right?
I guess, yeah. I mean, I don't know. I mean, that's.
I mean, because we have, like they did,
Why did they keep the lot?
a statement like that. If it's not relevant.
Okay. It did say that,
Conditions that you had on the.
right? Okay,
And so this whole 13 is completely stricken then?
Yeah.
Even though it wasn't stricken in their decision, it is stricken by virtue of the fact that it's not applicable anymore.
yeah, okay.
Okay.
Same for 14. Oh, so 14 is,
Yeah.
oh, I make no, 14 was,
So that was, this is where they got rid of all the minimum lots.
Yep. Okay.
So it's all stricken. And then the 15 was the maximum ground coverage of the recreational building is at 1,000 square feet.
Mhm.
This was not struck by the hack decision. Exhibit 3 plans indicate a footprint of 3912. And the current site plan has a footprint of 3975. This remains to be an issue this appears to be an issue remaining to be addressed in the plans. And they do under B, give a kind of maximum interior space, 2,800 square feet, 100 on the ground and basement levels and 800 square feet allowed on the second floor to reach the maximum interior square footage, 2,800 square feet.
Yeah, so that should, A and B should be what is
Yeah.
on the plans. And then I also had 15E, the 8 parking spaces, both exhibit 3 and the current plans have 10 parking spaces,
Oh.
so.
That's great. We have more spaces. Right? I'm
Yeah.
assuming that we're gonna go with the 10 spaces.
More improvements, sir.
Well,
Yeah, I mean, I think it takes away the.
I'm just,
open space.
can somebody answer the
But
question?
it also, wait, hold on, but what, just because later on it does talk about, they did strike something that said something about the on-site parking or street parking, or, sorry, something like that. So maybe having 2 more spaces.
Well, I was gonna ask the question about, I don't see a total number of bedrooms that have been approved under this plan. Can somebody tell me what the total bedroom count is? I didn't see that listed anyplace. And what the total number of parking spaces are. I was gonna try to count it and then I just gave up. I got bored.
Yeah, right.
I was doing the math. Just as, well, we can talk about parking later. I guess.
Yeah, all right,
If
so
it's-
maybe,
If we can get that information, that would be great. Because in here, it does reference what we had approved, the numbers, and I can't remember what they were, but there was no comparison to what actually the new plan. Shows. Oh, and then number F, max minimum lots square footage of 38,196 square feet.
which one is that?
That's
F.
F.
Oh,
Is
right,
that for the
yeah.
building? That's for this building. It says site exterior architectural design subject to final review and approval by the board prior to issuance of building permit. So are we
Yeah.
reviewing these buildings as the HDC?
I think we normally do some.
Right.
Yeah, I think we did not,
Okay.
we did not punt it over to HDC.
Right,
Yeah.
okay, so we need to do that then.
Yeah,
Review them
so F.
architecturally. I mean, that also is the same.
Same thing
Mhm.
for G.
Yeah. Okay, the access is for the pool is the same as you can assume. So there is a pool size dimension on exhibit 3, which is what we are using as a pool size, so that it's not 20 by 48 feet anymore. I didn't bring the landscape plans. Is it this size?
Okay, so the pool, so. It's 16.
What is the pool size?
What?
John, do you know the pool size?
Just a second.
So as indicated on exhibit.
22 by 52.
And that's the plan on the 22820 plans.
They're both, yeah, the pool did not change between the two, exhibit 3 and the current.
And what was the dimension again?
22 feet wide by 52 feet long.
Right? 16 B, yeah.
And then, Jim, did you look at, did you look at 17F? Because I know that was something you were,
I've got chance.
okay.
What is that?
The walkways?
On the landscape plan
Native
to
plants?
make sure
Oh, native plants.
that native, because I
Yeah.
thought that might be something that's kind of your wheelhouse.
Yeah, I'd like to keep that in there.
Yeah, no, it's in
still in
there,
there.
but I just want to, just on the landscape plans, I didn't know if you had a chance to look at those. It seems like those might have been, John, you said those were submitted on March 31st.
Yeah, they're dated March 31st, and I'm not an expert in what's a native proper plant. I mean, I know I'm pretty good with plants, but I don't want to profess
Yeah,
to
yeah.
know that one.
Understanding.
Maybe we can ask the applicant to verify that they're all on the list.
Okay.
There's a list put out by Massachusetts that describes that. It's easy to just reference that.
Yeah, they
For-
talk about one landscaping with native plants on Nantucket by the Nantucket Biodiversity Initiative and Nantucket Conservation
Yeah,
Foundation.
I just wanted, okay. Someone needs to just check the plan and make sure that that's true. And I just, I think I'm remembering correctly, Jim, you were like pretty into the making sure that that was included in the comp permit. So I just thought maybe you would want to lay eyes on that and just make sure.
And non-invasive stuff.
Yeah, like non-invasive, all that. All right.
So the second F, is that supposed to be stricken since we don't have single family? Walkways for multifamily.
Yeah, so I thought I had a strike through on after walkways for, does walkways for dwelling units must match? I mean, I don't know what we call those buildings, condominium
Buildings.
walkways to just, or how about walkways to buildings, to residences? Something.
So if it helps, there's like 3 different kinds of walkways.
Uh-huh.
Originally, I think there was a desire to make it so that it was sort of uniform for the single families and the condominiums. There's walkways that are adjacent to the roads, which have a certain finish. They're dark gray chip seal. Then there were originally brick. There's no brick ones proposed now. And then there's some other pea stone with a chip seal that sort of go to the units. And then where I believe there's maybe a doorway that would serve a single unit or possibly 2, then it's just pea stone. And they're all on the landscaping plans.
And then what are the ones around the roadways?
It's the dark gray chip seal finish.
Those are the curbs around the major roadways.
Yeah, it's a curb with that, and right up next to the curb in most locations would be the sidewalk. And then there's internal, walkways between, from units to the sidewalk to the parking. And then some of them are like from units to patio areas and things like that. In around the clubhouse. It seemed consistent with what I think you were looking for, but the roadways themselves are paved with regular pavement.
This says, under F though, it says the proposed roadways would be, the sidewalks adjacent to the road. Okay, yeah. There we go. No brick walkways. proposed or anything.
So it's more detailed in the newer plans than it was in Exhibit 3. And it lays out the different materials for the different locations. They're on the landscape plan with sort of a hatching pattern.
Okay. So, did we just ask the questions that we have highlighted?
I think let's just go.
So I had 18
I did
highlighted from the associated drainage calculations should be updated to reflect the proposed conditions if this is an acceptable increase in impervious area consistent with the hack decision.
So.
So if you'd like, I can sort of give you a highlight as to what seems to have changed. It's hard to pin it all down. But from the Exhibit 3 plan to the current plan, there is a bigger and more uniform non-disturb buffer around the perimeter of the project. In the Exhibit 3 plan, it was more of a wavering line. It's roughly about 25 feet, but not perfect everywhere, because there were a couple of spots, I think, where there's some grading into there that they would reestablish. And then along South Shore Road, it's deeper. And that's another comment when I get in, get down through this letter. So that's the perimeter's changed. That reduces the usable open space. It increases the unusable open space. And there is an increase in impervious area, impervious / semi-pervious of about 25,000, little over 25,000 square feet, 25,683 according to the plans. So this is something that's the difference between the plans. So this is something I think that you have to talk about and make decisions regarding that.
Okay. Then 19.
Wait, so 18, how do we? What do we think about this increase in the impervious space?
I guess I just want to look at it more. I haven't, I mean, look, I want to look at it based on the plan that
All right, so we'll circle back.
Exhibit 3 and then
We'll
compare to
circle
the
back
next-
and do
yeah,
the
we'll circle back.
plans
to that.
Clarify.
And I guess my question is with these, I mean, clearly there's a difference of, 25,000 square feet at least. What do we do? Do we say you go back to this number or that number, or are we just reviewing to see if they're in compliance? That's
I think we have to look at the plan, like Lisa said, because if compare the two plans and see where the impervious, where there's more impervious, and if and then decide if we don't want that, then we hold it to the decision, right? Yeah.
I should note too, I think that, and Leslie can correct me, the way you would normally do your plan review, I think it would go to the building inspector if he's hearing from you, if you've confirmed compliance with the final plans with the conditions, then he's either going to base a building permit on that approval or not. So that's why I'm saying to keep note of the issues that you find not in compliance, notify the developer, and then it will definitely come up at the building permit stage that he would look to see,
right.
Did they get the approval from the ZBA?
And
Right, so we
Right.
could either require them to come into compliance with Exhibit 3
Right.
or, sorry.
Just go.
Madam Chair, I think during your review, you have the authority to grant approval for them to exceed what was shown on the HAC plans, if you choose to do that.
Mhm.
And there may be a valid reason. And that's, I think, when we'll hear from the developer, like, why did
Why?
this change?
Right, I
Because
think
the
I'm
why
just-
may be really important, and it may, sway your decision or not to
Right.
allow a deviation.
Right, I think,
Right.
so the note that I just made was review plans and circle back, the same thing
Right.
with the other one that I had a note about that to circle back.
Just give me a list of what we want to be sure that the plans reflect what the notes.
Well, we're gonna
Yeah.
circle back.
So the
Right.
parking spaces, that was it. The 2 additional parking spaces to circle back.
Madam Chair,
Yes,
I think the implication is by virtue of the information here is the drainage calculations. Stormwater runoff, how that's being handled, if the impervious surface is increasing. I think that's really, the plans are so different. I don't know how really,
It's like we should be starting all over.
I don't know how we compare them, honestly.
Mark,
Madam
just to
Chair.
clarify that's what the litigation was about.
It's about drainage.
No, it's
stormwater.
about whether it has to come back for approval. And
Oh,
what,
I understood that.
starting anew, that's all.
Yeah, but we're not gonna be able to compare the plans and make that kind of calculation.
Yeah.
It's just not gonna happen.
Madam Chair, we're talking about the HAC plans and final plans that you have, and those
Yeah.
are fairly close.
Right. Yeah.
Well, he does a thing here where it's, it gives us the difference, 25,000
Right.
square feet more of impervious, semi-pervious.
Right.
Yeah, 30,000 more unusable open space perimeter buffer. So we have those calculations. But we don't have a new drainage. Do we have new drainage calculations?
Well, they have to be redone,
Yeah, they have to be
depending on once we look at the plans and then can have a.
Well, I guess I would understand what the drainage looks like, although I guess anybody can make anything work, based on the current plans. I'm sure they can get it to work somehow, but.
So if I may, Madam Chair, through you to staff. So I guess that's sort of the question when it comes to these impervious surfaces and then the drainage calculations. Are we going to anticipate revised drainage calculations or are we saying to them, hey, we think there's a discrepancy here. You need to provide new drainage calcs, or are they just going to come back with drainage calcs on their own?
Well, Mr. Chesky has reviewed what they've submitted for the engineering plans, but the drainage calculations, if you approve an increase in impervious surface from what the HEC plans showed, would obviously have to accommodate that.
Right, and basically his note says the associated drainage calculation should be updated to reflect the proposed, and we haven't seen this yet, I don't believe.
No.
So when they come back.
Yeah. Okay, so that needs plan review.
Right.
I didn't have any issue.
I had
with the
lighting. I just want to make sure in lieu of town meeting with the new dark skies regulations that all that is designed. And maybe, I don't know how to do that, but it should be designed with the new bylaw in mind.
Well, unfortunately, that needs to get approved,
Yeah,
I
it
think,
hasn't.
by the
AG.
AG. So I don't think any of that is law at this point, although I think,
Well,
It's
it does
law
go
until it's
back-
voted down, right, by AG.
but
right?
I think you have notice, right? And
Because you can't do any zoning changes.
Yeah, so just saying, would this decision was before the night sky?
In the application. What your local regulations were at the date of the application.
Okay, so that doesn't matter then.
No.
So then once they're all set, they'd have whatever gets approved for the bylaw, but it was like 5 or 10 years to comply.
Wait, meaning, once they're approved. So we're not going by their old lighting plan.
No.
Even though that's what this decision was based on. Did we,
In the dark skies, the article that it wanted to.
yeah, it has 5 years to allow people to come into compliance.
Right, so
Yeah.
this, their date of the application, George said, is when the clock started ticking for them for what they need to comply with.
Okay,
But once, those guys come in, they'll have whatever it was. 5 or 10 years.
okay, so we don't need to follow up on that then. Oh, I had a question on the next one, actually. Why don't we get the fence? I mean, I just don't understand why they struck not having a split wall fence.
Which one was that?
18,
19.
20C, 20B, 20B.
I don't know, but I drove by there the other day and it looks like there is split rail fence with posts that say open space requirement, or it says something on the post. I can't remember exactly what it says, but there is a split rail fence that kind of like delineates these areas like this, and that this is all like natural, and there's the split rail fences like that, and then it's like this.
Well, maybe they could
So
show a plan that where they do have split wall fence would be.
I think that is-
Right. Right, saying that it's not required, right? I was just asking the question.
In that next one.
I think the buffer student should get at least 1, 2.
And Madam Chair, it's my understanding, and the applicant's representatives are here and can correct me if this is wrong, but I believe the fence that's up now is part of their NHESP permit, not anything to do with the
Okay.
comp permit per se.
Do we get confirmation of that?
The applicants are here if you want to have them confirm it.
Sure. Oh, okay. Hi. Sorry.
Hi, Don Bracken, Bracken Engineering. I can confirm, we laid out the fence that's there, which was based on natural heritage approved open space plan. Thank you.
Thanks.
Is that shown on the plan? Is that shown on the plan?
It is shown in the records with the East Natural Heritage, the approved plan that's recorded at the Registry of Deeds. I assume it's somewhere in the records, on the town's records.
Do we have-
But we will show, it is also going to be shown, if it isn't already, on the
Do we-
final landscape architectural plans
Okay.
as an existing fence.
Are those plans included in this package?
It should be on the landscape plans.
Is a recommendation. I recommend that the landscape plans also note list proposed plantings and the portions of the perimeter buffer to be restored or revegetated as indicated on the site plans.
Right, so.
So if you guys could add that information if it's not already on the plan.
Yes, we've gone through all these issues and comments that are raised, and we're in the process of updating all the plans for that. I think a lot of information was shown, but there's more information to add based on Mrs. Jessica's comments, which we plan on addressing.
Can you show the fence on these plans?
Sheet 2.2, L 2.2. It goes along the inside of the property, along the 25-foot buffer.
I don't see them.
I don't have.
Don, not to be silly, but is it, or through you, Madam Chair, is it the dashed line?
Yes.
Thank you.
Just a general comment. It makes it hard for us to, when there's no legend. I think that's pretty standard to put a legend or to have us figure out what a dotted line means. I mean, it could be a property line, it could be anything.
Is there a legend below the title,
Yeah.
Jim?
There is, but it doesn't show. a
Right, but
fence.
it doesn't
Doesn't show a
show.
fence.
So
We'll make sure that's clear on the next set of plans.
okay. We're not engineers, yeah, maybe. So.
Oh, I just questioned about, well, go ahead. Did anybody have anything? In 21 or 22, I had something in 23. Just a question.
Okay.
Go ahead. Our gutters, there's a question about if gutters are proposed.
I don't think John had the architectural plans, but the architectural plans did not show gutters. Going through these comments, I did inform the architect that they're going to have to add gutters to the plan.
And then, okay, and they'll go to dry wells.
Obviously, drainage.
Right, that's part of the drainage. Yeah. I'm just making a comment that they struck no customary home occupations shall be allowed. Item 26, that hack struck that. Which is frustrating.
Mhm.
No parking permits. And then 28 references the Nantucket Historic District Commission again. So it says any future proposed changes to the exterior architectural features shall be subject to the jurisdiction of the Nantucket Historic District Commission. So I assume that'll come to us.
Madam Chair, on that one.
Yeah.
I think this may be similar to the conditions in Sachem's Path that you all served as the HTC, you approved plans, excuse me, not Sachem's Path, Beach Plum Village. And then once the units were conveyed out, any future changes actually went to the HTC. They didn't continue coming back to you. So I think that's how this would work.
So it should just be worded differently, maybe not any future proposed changes or any changes proposed post unit completion or sale. I mean, I think any changes that happen while the project's in process should.
So you can say once, we can say like once issuance of a CO or.
Yeah, exactly. So can we just clarify that?
I don't really think there's an opportunity to clarify the HAC decision, but you could perhaps ask the developer to put some sort of note on the plans or something like that to clarify the operation of that going forward.
Okay.
Madam Chair, if I may ask a question for
Mhm.
you to staff. Similar to planning, will zoning be reviewing legal documents such as homeowners association, declaration of trust, et cetera? Because I think a lot of this may be, some of these conditions may be applicable to that as well.
It's Sachem's Path, isn't
I'm trying to remember. I think so, but I don't. I would stand to reason that we would have to bless legal docs, but.
it? Thank goodness.
I don't, how have you
I
look on
don't
that? in the
remember, but
past?
there's something in, there was something in here, what was that? Where we did have
John was
something about
administrator. I don't
those
know.
and it was struck, I believe.
Yeah.
I don't. think there's much.
I will either see it when we go through or I can try to find it, but
Yeah.
I did read something about.
I'd have to look at the exact language, but if this was not a 40B and it was, say, a subdivision, they would be submitted for staff review and board approval. So we'll have to see exactly how that's to be handled. So that's maybe to be determined for right now.
Thank you.
I just had a question on 30. How is trash being handled on the site?
There are some dumpsters, I believe, on the plan, but I don't have an exact answer for that. We'll have to get that answer for you.
Okay.
I think there's
I
one
have-
by
I
the
just-
community building, and we had others that were in the old open space that we had to take out when we increased the open space around the perimeter.
And so they're gonna be dumpsters that if you live in building, number 9, you're gonna walk the dumpster and put your trash in there.
I'm not really sure.
Okay.
I'm gonna have to get that information.
And I'm
for you.
assuming they're gonna provide, what's the acronym? Non-recyclable, non-compostable, compostable, and then 2 recycling bins.
That, we'll have to get that
Okay,
information back
I'd
to
like
you.
clarification on how the
Yes.
trash is gonna be handled. And do we have a plan that denotes where the other mechanical equipments are gonna be located? It's just says it can't be in the setback. I'm just curious where they're being placed on the sites.
I'd have to look at, we do have landscape plans for each individual building. I believe they're shown on that, but I would have to double check.
Are you doing that one under 31?
Yeah,
Air conditioning?
no, that's also under 30. No air conditioning
Oh.
units
Sorry.
and then the mechanical equipment.
They may be on the architectural plans as well.
Is it on the landscape plan?
Is it showing there?
Mirka is the landscape designer here in the back. There are some dumpsters on the plan, like she said, but. talking
What about the AC units, Mirka?
Pardon?
The air conditioning units?
That were not located as of now, I don't believe so, but I just want to follow up on the dumpsters. They were as through the process, the protected area was growing, so dumpsters were located within areas which were not supposed to be disturbed. Therefore, we pull them out and they are revised in a revised location, but not on the plans you have in front of you. So
Okay,
there was something we've been
that's something
working in
we'll follow up
meantime.
with. Okay. And 32 just talks about, again, it brings up the drainage calculations. So that's just another follow-up just because of the drainage.
So we need to look at the plan for that. So dumpsters will be on the updated landscape plan. Okay.
As well as AC units.
The AC units are on, Joan just showed me, they're on can I say that one? Sorry.
No, they're on the architecturals
Yeah.
for each building. Okay.
Could they be on the landscape plan also?
It'd be easier maybe,
Mhm.
just to show them on the landscape plan.
Mhm.
Okay, so we can make that request. John?
Yes.
Can you talk about condition 32? Where it says the individual lots are proposed, no individual lots are proposed. Sorry, I can't read.
So, yeah, your condition said ground coverage for each lot shall not change from that depicted on the comprehensive permit plans. Obviously, we know that those plans had both multifamily units, single family lots. Now it's all one condominium, so there would not be any individual lots per se. There's no roadway right of ways. There's just one project. But as I noted and we talked about under the condition 18, the table there, that there is an increase in the overall ground coverage of impervious and semi-impervious
Right,
on the between exhibit 3 and the current plan.
right.
Right.
Can I explain the increase in impervious area? I wasn't sure if I could say that originally.
Yeah, you
but-
can, and then could you, and the increase in the ground
cover.
coverage. Like, we, obviously, there's, more on the community area room or community building, but where else is the ground cover?
The 25,000 square feet is pretty much spread out throughout the whole site. And the reason why that increased, it was primarily the walkways that we had to add to go to each building. When we first designed the plans, we were told we only needed one handicap access entrance per building. And then after the HAC decision and final landscape, architectural plans were done. It was determined we needed multiple handicap access points to each bedroom. And so the increase in the impervious area is primarily the pathways that are required under ADA compliance to get to each door that's now indicated on the site plans. In the increase in the size of the community building, that's the way it was submitted to HAC. So that's what we've kept on the plan. I believe our team's interpretation is if that's how it was approved, then even though it wasn't specifically stricken from the decision, that it was approved by the HAC in that format.
So the plans that you submitted to the HAC showed the current community center.
Correct.
And what
But they
were
definitely,
those, what was the date of that plan?
I
the
don't,
228.
I don't have that
Okay,
handy.
28.
I think that was in December of the HAC set of plans.
But they clearly make a condition that the maximum interior space is 2,800 square feet. So they not only
Yeah,
didn't strike it, they added a condition about the size of that building.
yeah.
So I think I'm not in agreement with you
Yeah.
saying that.
That's, I think
Yeah.
it's a difference. I think they looked at a different, whatever the plan that showed the 1,000 square foot. Because
I think
it
that-
doesn't make sense otherwise.
Yeah.
Okay. All right. We'll have to double check.
And
that.
could you, in addition to getting us the number of parking units, the number of bedrooms, could you also give us a comparison of the ground coverage?
Yeah, we can do it. The number of bedrooms and parking is shown on sheet 4 that you already have in the lower left-hand corner
Of which,
Of which set?
of the current set, the March 30th set. If you go to sheet 4,
Landscaping or the architectural
Landscaping.
plans?
the civils, I'm sorry, the civil
Civils?
set, yeah.
but that's on, and is it shown on the 22820 plans, which are the ones that the hack based their decision on?
I believe every set of plans had a breakdown similar to the one that's on the
Okay.
current plan showing the number of
Okay.
bedrooms and parking.
All right, cool.
I know. I can't see. Magnifying glasses on.
Is it a chart or is it just?
It's a table in the lower left-hand corner. Says parking summary, and in the parking summary, it lists the number of bedrooms.
Does anybody have the 22820 plans?
I do.
Good.
Can you tell me on those plans what the number of bedrooms and number of parking spaces are?
Yeah, if it's on the same sheet, let me just check.
Here it is. Oh, one second. Sorry.
So
Parking summary.
parking summary says, 283 bedrooms proposed. 299 spaces provided, 10 of which are in by the community building.
And that's
So
on 22820
Yeah, that's on it's actually sheet 3
sheet.
of the 22820 plans. And then there's 20 total accessible spaces, 6 are van accessible.
Wait, I'm sorry, can you say that again? How many?
There's 20 accessible spaces,
Rooms,
6
6 are
of-
van?
6 are for vans.
Okay.
6 of which are for vans. And are those part of the 299 or are they in addition?
Part of, I believe, usually counted as the total. And so just for the record here is the 2 sets of plan. I mean, that table is the same in the February plans and the March 2023 plans. So that didn't change.
So the same number of bedrooms and the same number of parking spaces.
And how many bedrooms was in the original? I mean, not that
I
it,
don't know. I don't
it's
remember. I can
it's
find
listed
it.
in here somewhere.
Okay. Oh, all right. So the
The ground coverage in item 32?
grant, how much the, What was that?
Oh, the clubhouse.
Oh, yeah. While you're looking at it, can you look at what the clubhouse looks like on the 2/28/20 plans?
The clubhouse, and I actually listed it in my letter, but the clubhouse looks similar. It's a 3,912 square feet
Oh,
on
right.
the February plan. And it's 3,975 in the March plan.
Okay, yep, I do remember that. Okay. Thank you. I was just thinking something.
So in terms of parking, is there a waiver needed for this? I mean, not that they, are they meeting the parking requirements? I guess is my question, with the number of bedrooms in this development, because it seems to me a lot of the studios and one bedrooms will likely have two cars and not just one car. So I'm just wondering how they fall relative to the parking requirements that would have been required.
I'll have to get those numbers for you. I don't
Okay.
have those handy. They may be in the report somewhere.
Thank you.
Wouldn't it have been like early on in the process when we talked about the waivers? That we would have done a parking waiver?
Right, in the last one, but this is more bedrooms than we approved, so I'm just.
But do we go back and redo the waivers? No, I think we already did the waivers, so,
I'm just curious.
yeah, okay,
I mean, because I think it's a, well,
yeah. Okay.
again, I don't know that. It's just a concern of mine.
Yeah.
Considering what's happened at Richmond with parking, I think it's a really big issue.
Yeah, it is, I agree. And then I have the same question on, I guess, or just if you can explain 33, why it wouldn't be applicable about the local requirements concerning roadway construction?
Because there isn't, so the way I read that decision is that there was originally a proposal to do subdivision roadways,
Mm-hmm.
and now it's a condominium project, so there isn't a subdivision roadway that could ultimately be submitted
Right.
for acceptance to the town, or
Right.
something
okay.
like that.
Okay, I see what you mean. Okay.
But I also did compare the cross section to the subdivision regulations, and it would meet or exceed subdivision regulations for the cross section anyway.
Okay.
So it didn't seem to be, one, it was questionable if it applied. Secondly, if it did apply, it would be okay anyway.
Okay.
Madam Chair, if we're ready, I have a question on 35.
Great. Go ahead.
Who is the town's, the board's transportation engineer?
I don't remember who it was. We had somebody during the first review.
And has that, I guess, then the question is, should 35 be referred to that person per John's recommendation?
Is that is it the people that did the traffic study for us?
I assume.
So if I may, on that one, the HAC, and I think that maybe the memorandum, I'm not a traffic engineer and I'm not someone that should be reviewing that, but in the HAC decision, if you read the write-up, a lot of it related to fire department, fire chief concerns. And they basically said that the fire department issues can be addressed with the fire department. They weren't sufficient to require significant revisions to the plan. And that they can work that out is what the HAC decision said. Now, there was a memorandum provided by MDM, and there's some paths, fire truck access paths included in that little, it was a pretty brief thing, maybe, I don't know, 3 or 4, maybe 5 pages with some attached, what they call swept path plans showing how a vehicle would get around. I'm not sure what it wasn't anything to do with, I don't believe, with things like traffic counts, and it was basically geared towards the fire safety aspects, if that helps.
Madam Chair, the condition says that the final plans must be submitted by a transportation engineer. It doesn't say for our transportation engineer to review. And they've done that. And I have been in communication with the fire department, and I think they're generally in agreement with the plans that have been submitted, but they do have some additional comments that they want to have addressed. And the fire chief was here today, but he had a prior commitment with the town and had to leave, but he'll be speaking with you at a future meeting when one is scheduled, or providing comments in writing.
So I think my reading of that HAC decision recognized the fire department concerns. It's not that they didn't just say they're not required. So we need to make sure that they're in agreement, the fire department and whoever's drawn up a plan.
Okay.
36 needs follow-up too. It's again about stormwater management.
And I did provide also a separate appendix that sort of listed all of the stormwater standards under the DEP reference for the stormwater regulations. It just, I mean, this was big enough and it seemed easier to break that out as a separate sheet. And I don't think it makes sense to go through all of those right now. We got enough things to deal with, but I presume that the applicant's engineer will be reading those and looking to address them anyway.
Those are the last 4 pages, John. Oh yeah, here it is.
Yeah, it's called Appendix A, Compliance with DEP Stormwater Regulations.
I got it.
I know, I wrote on the top of it, the conditions of it. that way,
Okay,
just so that
okay.
makes it easier
Oh, yeah.
to hear.
23, 36, 40, 35, 117, and 126.
Yeah, just made it easier for me to kind of figure out where I was. You want to say something, John?
Yeah, I'd just like to agree with what John said about the drainage. We've gone through all the comments. We can address all of them. There is one issue that I don't think that we're going to agree on, that we're going to have to discuss further, and that's the dry wells for the roof runoff. We both have a different interpretation on that, but we can see if we can work that out before the next meeting.
Okay.
$38 is more about the impervious area.
38.
It's 38, yeah, it's just more about impervious areas. 40 needs fall, yeah, you have that written down already because of the appendix A. 41 is final construction plans. Relative to, that's relative to the roadways. I think that's just a general comment.
So does 41 get struck? Strike out the word subdivision?
But that's that's how Hack wrote it, right?
It's just, well, I was just going back to what George said, that if it wasn't specifically struck, but it's not relevant.
Right, do we strike it on, so we strike it in our decision, in our comprehensive permit?
I'm just,
I don't know the legalities of that.
I don't know how that works, so I'm crossing it out.
Well, 43 is the SWPPP has been submitted. If desired, this will be reviewed under separate cover prior to construction. I think that is desired, right? That's the stormwater plan.
Assume, but I assume that's still somewhat in flux with what we're waiting on,
Right.
right?
Yeah, so that's a follow-up though, 43.
And Madam Chair, through you on 44, just out of curiosity, when is the appropriate time to assess ADA requirements?
Who's doing that?
The new landscape plans that we're working on, we were very specific on meeting the ADA compliance for each unit. I think previously we showed in general how we were going to meet it, but the new plans will show for each individual building, the access points and how we're going to meet those requirements.
Great. Thank you.
The applicant contemplating another set of final plans?
Yeah. I think that's what I just underlined that myself. So. Right, so there'll be another set of plans once, right? There'll be another set of plans once all of these changes and everything, and those will be.
That's correct. And we're actually about 99% done with all these changes that I said we would make. So like the handicap access plans, the updated landscaping plans,
And
all that stuff we've been working on since we got the report.
Be nice to confirm to agreement on, when your review can be completed by.
our review of those plans.
Yeah, so that you're not caught short.
Yeah, I mean, I think I agree, sure, but I think we need to. We need to decide what. Time frame. Well, no, not the time frame, but like, just like keep coming back to the community building, right? Like the decision says 1,000 square feet for that building. I'm not on that, showing that on the plans, so. I'd like to see it 1,000 square feet.
I would too.
Absolutely.
And also you brought up a good point about the mail situation in that building. It's like a 10 by 10 room and but there's like a bowling alley in the basement, it looks like, so.
There's gonna be,
This
So-
would address the, just
Yeah.
that concern.
so. So yes, so I would think, we would want. I want to review the plans, 2 weeks.
At least, yeah. So I think, I don't know if you're the agent to tell the architectural team, but I think I feel pretty strongly that the community building should meet the PAC requirement that was put in their decision. And so maybe there should be some redesign of that building, or at least it should be updated on the site plans to reflect that. And new square footage is submitted.
Yeah, I'm not the agent to make that decision. I do know that the attorneys on the team feel that they, it sounds like they're confident that, they can go with the configuration that we have. So if you want to discuss it now, I'm sure one of them has their hands up right now.
Okay.
Um,
Just go to Leslie first.
You're probably saying that, I think Leslie was gonna say.
Sorry.
I apologize. They're probably gonna say it was in the exhibit 3 plans, I would imagine. Yeah. So when HAC approved those plans, that would be what you'd go by. You'd compare exhibit 3 to this final set.
But even if they put a specific condition into the decision that addresses a different ground cover
Right.
and.
And the ground cover increased still, so it was 3,912. And then went up to 3,975, which I know is de minimis, but.
But then under that, though.
So you're saying that creates a discrepancy for the ground cover?
No,
So
there's below that, then there's
No, yeah, so
what page is that? Oh, here, the page. Under that, it says.
no, I think that was
B.
ours. That was
Oh,
ours.
I thought that but it wasn't stricken.
It wasn't. It wasn't, yeah, they left it in there, but that was what I was trying to get at earlier, like the decision. Does the written word trump the plan, or does the plan trump the written word?
But shouldn't there be a plan and the written word that both interface and say exactly the same thing?
Right, well, that's
Instead of
what
having
we're
to go back.
Yeah, but that's why we're doing this exercise.
Oh, okay.
because, right, I mean.
That's right, what you just said, but is that, Are you saying that that's not true?
Go back to exhibit 3?
no, you do have to, because you
So-
have to confirm that exhibit 3 is consistent with the HAC decisions as John set them out. And then these final plans for compliance with that.
Yeah.
So I'm saying if that clubhouse is reflected on the plan that HAC approved, that would be what governs.
Not the
Unless it's
verbiage.
inconsistent with what you're saying about ground coverage, in which case the developer is gonna have to figure out.
Yeah, so that's it. So condition 15, the recreational building requirements. The decision that the board made was that the maximum ground cover for that recreational building would be 1,000 square feet. And that the maximum interior space would be 2,800 square feet, 1,000 on the ground and basement levels, and up to 800 feet more allowed on second floor to reach the maximum of 2,800. And then the additional land area resulting from the reduction in the footprint of the recreational building shall be devoted to green space or outdoor passive recreation. That was not struck. But the exhibit 3 plan shows a recreational building with a ground cover of 3,912 square feet. So what I'm saying is, which one do we go by? Because the decision that HAC issued says that it's supposed to be 1,000 square feet with maximum interior space of 2,800 square feet. But the plan that the developer submitted and that HAC put with the decision shows the recreational building at 3,912 square feet. So how do we reconcile those two? Because I would think that if they didn't strike the condition, then that's what it has to be. However, they figure out to make it
That's
comply
correct.
with the decision,
Yes,
correct?
absolutely.
Okay.
Yeah.
Great.
So we get to keep that in.
Yeah, so I think it should, stay 1,000 square feet with a maximum interior space 2,800 and
Be reflected in the plan.
be
Yeah.
reflected in the plan.
I agree with. In the
Yeah.
next iteration of the plan that we get.
I mean, of
Okay.
all the things
kinda
that were
common sense.
struck in that
Right.
hack said, no. This was one thing that was very specific and that they did not strike. And I think that's meaningful.
Well, I think, then you go question everything, like, they didn't strike, you can't do private functions there or have, I can't remember no commercial use. Does that mean that that's not stricken, that's still applicable because it wasn't stricken?
Yeah, that wasn't struck.
Yeah, no, I know that, but I'm just saying, since they didn't strike the one about the square footage.
Yeah.
Yeah.
Then it's still applicable.
Then it's
Unless-
still
The only
applicable.
thing they said, if it wasn't struck and it's no longer applicable, meaning like the
Multiple. lots of
multiple
them.
homes and whatever, then those references,
Right.
like all the references to this, to subdivision, it isn't a subdivision.
Right.
So those are no longer
Okay.
applicable, but this is a specific.
They should be struck or deleted. Shouldn't they? The things
They
that aren't
should, but
applicable?
what I'm saying is, yeah, but what I'm saying, the hack decision itself
Mhm.
said
Right.
that even if we didn't cross it out, if there's a reference to something that's no longer part of the project, then it's,
Right.
then it's,
Not applicable.
it's not.
Right. But by leaving it in there leaves room for loopholes and misunderstandings. It should be struck if it's not applicable.
Well,
shouldn't
I
it?
think what we're saying is we need to make a decision at a board. I mean, I'm gonna stand by that, the fact that it wasn't stricken and that they need to
Yeah.
redesign that building to meet that requirement.
Right.
And it's up to however everybody else on the board feels about it, but that would be my stance.
I think I think anything that references a subdivision, or like we said earlier, when I had the question about roadway construction, like
Mhm.
I was thinking just construction of drivable surfaces. I wasn't thinking when I read it of some, roads and subdivision. So that's why I had that question, which once he explained it as, of course, that makes sense. But yeah, I think that if something's in here,
I just don't want leaving words in here to be misinterpreted in 15 years and used against the bigger picture of the good. If it's not applicable, it just should be crossed off.
it should, but
Even if in our judgment, it's not applicable to what we've approved. You know what I mean? I want to be like super
right,
clear.
I just don't think that I don't think that we have the actual ability to change the HAC's decision, how it's printed.
But in our comprehensive permit, we would be able to write our own. Will we write a separate
Well, we have a new,
comprehensive permit that will address the way, the things that we're signing on to?
I don't think so.
No?
Yeah, I think it's just.
So then how do
The
we?
plan,
yeah.
the final, the final, plan for the hack decision, right? Will, the final plan and the hack decision will speak for themselves. That's why we're going through and comparing, and the applicant then has to, their plans, the final plans that they go from have to match
The decision.
the decision.
Yeah, it's not optimal. And other ways of doing it would be everything just gets redrafted, doing this
that's what I think
exercise.
should happen. That's
And
kind of
then,
the way.
and then it's presented jointly to the HAC for approval. Then you end up, that's your permit.
Yeah,
Yeah.
why can't we do that?
Is that the way it happens, or you're
It
saying
would
that's
be
the way?
good
it
if
would
they
be?
would agree to that, but they're not in the obligation at this point to agree to that.
That's- Okay.
Okay.
So-
But it would definitely provide clarity
Clarity.
because everything that
That's gonna
John
last
is
over time.
representing can all be in,
Right.
in one
So we have to
narrative
make
as
a
John has
motion
already
to
set forth.
Request that. Be
Well,
done.
No, the hack doesn't have to do any of that. They've already
Yeah.
issued their decision, right?
You have no ability to do it. If the developer wanted to do that with you, they could. They could set it out without, John has done this process for you. That's mind numbing because he's comparing everything and then using the plans and trying to do that. And something that would be much more clear also for future generations, when you look at one
Yeah.
document, would be a better way to go, is to have a final agreed document,
With
that
nothing
references
crossed off.
plans,
That's
no
sort of the
ambiguity. And
over
then
this
that's right,
subdivision.
and then that would get approved, but don't let me
But why can't
lead you
we
down
do
the
that?
primrose path because they don't have to
It's-
agree to it.
Yeah, I don't think, I I think I'm having deja vu from Sachem's Path or something right now where we talked about this before. Like, it's just,
Is it
would be-
impossible? It's
For sure.
impossible?
Let's just focus
It's
on, let's
impossible.
just focus.
No,
on
it's
the task
possible.
at hand.
It is possible.
Yeah, let's just focus on the task at hand and we can have that conversation with the developer later if they want to.
But is it if they want to, or if we want them to?
If they want to. With the
Well, then
hack,
why would they?
well, then
They
probably won't.
Right.
So you
And
have
HAC
to
doesn't, and HAC doesn't have to
And they're not
accept
gonna
it.
require them to
So
do it.
it's a lot, it would be a lot of work and it,
But look at how much work has already gone into it. It doesn't make sense to me, I guess. I haven't been on the board long enough to know
Welcome to the
what the
process.
standard process is, but
this is.
in the
standard.
construction world, everything gets updated together and it all makes sense together.
Yeah.
This doesn't make sense to me,
It's, I know.
that we're not
The-
able to
You need to go,
require that.
you need to go to the State House and start lobbying.
No, but I,
Challenges.
No time.
but Susan, I should note, I mean,
But you're
you
telling
can
me
ask,
that is,
you can make the request.
Yeah.
Because it would be the better way to go. I
Totally.
like to have a, one-stop shopping on your ultimate thing and
Yeah. For-
people can
for
look at it.
Benefit as well as the
But-
towns, but
But it's,
Well,
I'm
but-
just saying,
yeah.
they're not under an obligation to do
Right.
it, but it's certainly something you could ask for.
okay.
And especially if they end up asking you for little adjustments here and there, and they're saying,
Okay.
well, this is an improvement, accept this change.
Mhm.
That would be something that then it would make sense for them to offer you something or agree to provide this final.
It almost
document.
makes me want to stop in my tracks right now at item number 44, and we have many more to go. Wondering, are we going through this process without?
Well, the problem is we have to go
Without-
through the process anyway
Yeah, we have to, no matter what we do. we have
by
to-
June 16th.
Yeah, so we only have
So-
till 4:30. It's now 2:30. Let's just.
Okay,
keep
I'm just
moving.
trying to understand
Yeah.
the process,
yeah.
I know.
and it doesn't
Unfortunately,
make
the housing
sense.
I know.
appeals doesn't
Yeah.
make
Just
sense.
for your time frame today, I want to remind you that you have an executive session for other litigation
I know,
that you have to
we have to do
Stop
today. So we
the
should stop
discussion on
it.
this, maybe 3:30 at the latest, 3:45.
You think it'll take that long?
I don't know because I'm recused.
I know.
Need another meeting too, please.
We do, yeah, we've been
Trying to figure
And-
that out.
we tried to figure that out.
Okay, so,
Okay.
so 46 is more about the stormwater plan.
One last
30.
question on that
30.
subject before we move on, sorry.
Mhm.
So who is going to go through all of this and strike all of the new ideas and answer all the questions?
We're not drafting a new decision, so no one's gonna go through and strike it.
This is
And
just notes. for
These
us
are
to-
just notes for us so that
Okay,
when we
to
look at
talk.
the next plan, when we look at the plan, or when we next meet, I guess, next meet.
So
with
they
the-
are required to give us an updated plan.
Yes,
Yeah, they
final
have to
construction
submit
plans
final construction plans, yeah,
and answer any questions that we have.
yeah,
Okay, and in what form do they answer our questions?
a presentation.
Yeah, I mean, John, can you speak to that? They would usually put it right after John's.
Yeah, we actually have that already drafted.
Okay,
Great.
We've been working on that.
all right, I'm
Perfect.
still learning, sorry.
Okay. All right, so, so 37, no one had questions on,
37?
sorry, did someone have?
It's 40,
Did,
46, I
46.
just mentioned, and then 47, I agree with John's recommendations.
oh, sorry, I'm looking at two different lists.
Lisa, for what it's worth, I do too.
Thank you.
You do two what?
Agree.
I agree
John.
with John's comments on 47.
That one isn't an item. It has an action item. Does anyone have an issue with 49?
I was just making a comment about illegal parking and safety.
On.
On 49.
Well, I was asking about, assume that this condition specifies a minimum width is typically required for fire access. This would be satisfied as all proposed access roadways are 24 feet wide, and I think a lot of them are They're two-way, right? I don't know. I remember talking about the width of Amelia Drive and how, and I don't remember how wide that is, but that once somebody parks even illegally on one side, it messes the whole thing up. So, and I have a real concern about the parking.
I thought that they crossed out our condition that there was no
Yeah.
on-street parking.
This is no on-street parking on one-way sections. They did not cross that out. And they didn't, no on-street parking allowed shall be allowed if such parking would narrow the roadway width to less than 20 feet in two-way sections. And all the roads are 24 feet. So they're not allowing on-street parking. I'm just knowing that it's gonna happen.
Yeah, totally. I thought I saw in one of these that it was,
Maybe it's further down.
that it was crossed out. But maybe because it's,
Well, that whole requirement, I mean, just because the fire chief, that's number E, has to review the plans. F I had circled, two of the roads have no problem provisions for turning around, dead end roads, blah, blah, blah. It's again going to the fire department.
I feel bad that he had to leave. I wish that we had known that, because I would have skipped to his section. I would have liked to hear heard what he had to say. So he needs to.
And the maintenance of the trees to not block emergency vehicles. That's just sort of probably under the maintenance.
And that too, if we have a chance to review the condominium documents.
The hydrant layout.
If we have a chance to review the condominium documents. I mean, again, legal documents. That we have a chance to review the legal documents when they submit everything.
Number 50.
Yeah.
Yeah, that's come up later. Yeah, that. Not blocking the roadways, vegetation. And then there was also in 52, the hydrant layout needs to be approved. And there was something about a hydraulic study for review and approval by the fire chief addressing the impact of the project on water capacity necessary for fire protection. And or other critical infrastructure.
Madam Chair, how, now that he's not here, how do the fire department issues get dealt with?
We'll have to have another carryover meeting, I think, right? And the fire chief will, I'm assuming, meet with the developer and.
And just so you know, we do have a firefighting consultant, Code Red, that had some correspondence in there. They are gonna address the fire department's concerns in a written letter.
Okay.
And
And
when
Madam
does
Chair,
the- sorry.
I have an email basically to that effect from the fire chief that I just received after he had to leave the meeting.
Okay.
Does that happen during a ZBA meeting?
I don't think so. They can meet.
But he'll come here and just confirm
He
that
can,
he's.
I mean, you'll get
he's-
confirmation that he's reviewed the plans and is okay with whatever's laid out and that.
Before we vote.
Yep.
Yeah,
know that.
yeah.
Yeah,
I mean,
Madam-
honestly, I don't know that it's his purview for fire and safety. I don't think it doesn't have to happen in front of us.
And Madam Chair, just on the 52 comment about there's not 52. One of these comments in here talks about adequate pressure for firefighting to be reviewed by the fire chief.
53.
We'll certainly have him do that, but Wanna Comment Water has reviewed the plans. They're going to install a loop system and they should have more than adequate water pressure. Talk to Mr. Willett about that.
They mean the developer is installing?
That's part of the project.
Yeah, so they're paying for that. What is the sewer concern?
I'm sorry, what was that?
Just the sewer concerns.
56?
Yeah, just the final construction plans for the sewer system have not been completed at this time. Now,
Mhm.
I don't know if I saw something that, I'm sure that's in the works. We just have to follow up on those final construction plans in the sewer system. David
Don,
Gray
do you
will
have a-
review.
Do you have an
this one.
update, Don?
Yeah, I can give you a real quick update on that. As you know, the town did install a gravity sewer line all the way up to the site, and they brought a pipe into our site. Our current plans that you have show us connecting to that gravity line, which isn't gonna be available until they upgrade with a pump system down at the treatment plant. So we're kind of in limbo on when that happens and when we're gonna actually need to connect. But in the meantime, we've also shown a sort of a placeholder of a pump system on the plan, similar to what we've already shown in the past. But obviously, we're hoping that the timing works out so that we can connect with gravity.
So this whole project is on hold until it's been upgraded at the plant?
Well, it's not on hold. It can go forward. It's a matter of when we actually
Well, we
need to
can't
tie in.
Activated until the plant? Is that right?
Well, that's why there's two options. So if the gravity line is ready or within a reasonable time when we have to use it, we'll just use the gravity line. If it's not, then we'll have to put a pump station in to pump into the existing line in front.
At the developer's expense? The
All
pump
that would
station?
be, yes, the pump
Uh-huh.
station would be private on
Okay,
on the property.
and do you have a location for that?
It is shown on the plan.
Okay.
Yep.
Yeah.
That was litigated with the HAC that, our position was that the developer had to comply with the sewer department's recommendation, which was the gravity line.
Yeah.
They ended up ruling against us on that, and they did approve Mr. Bracken's design, the alternate design that they proposed. So what he's saying, and, I think we're all in agreement, they're hoping that the timing works so that they do give the town what we were advocating in the HAC proceeding. In the meantime, though, the HAC proceeding, the order does approve their plan. So hopefully they won't build that plan and they will do the gravity,
Okay.
but he's saying the timing of it,
What
that's what it
is the
depends on.
sewer department saying timing is? Does anybody know?
That would be good to know as part of this.
Madam Chair, through you, I have a question on what David Gray submitted that we have in our packet here. David, if I may, David mentions that in the hack decision that hack has established one section, a contribution of at least 1 million to the $1 million to the sanitary sewer. And David is suggesting that perhaps something in the order of 1.5 million would be more appropriate. What are the mechanisms for that? How if we're not part of another agreement or writing a final decision, how does this come into?
That's
come into
right.
play?
It will have to be a matter of agreement. The HAC, they conceded in their decision that it made sense what the town's position was. But, unfortunately, hopefully it's not unfortunate because ultimately they will connect to the gravity. But it's left sort of up in the air. The HAC said, yeah, it was a good idea what the town was suggesting. And depending on how things work out, there'll be a contribution. But at this point, it would be solely by agreement.
Got it.
With the developer. I mean, I should comment, the developer is supposed to be partnering with the town. You know, we had that spirited discussion at the beginning
Right.
about that, but, you know, hopefully that would be reality of what happens. They're a good partner and you end up with a nice agreement in terms of connection to the gravity line.
One more question about if they do
Thank
have
you.
to go sorry, I didn't mean to interrupt.
So,
If they do have to go the pump station route, can I just go back to that? And then town sewer gravity becomes available. Is there a time frame in which they have to abandon the pump station and hook into regular town sewer?
Right, David should really comment on that.
Okay.
David should probably have a further discussion with the
Okay.
applicant and then comment to you about it.
so yeah, so for the 1.5 million, you know, how, is that something that David would have a conversation with the developer about, asking for that additional 500,000? Because we don't, I mean, I totally take his word for it and he's the expert.
They should talk about it and let's see.
Yeah. I mean, I'm in favor of an extra to
Yeah.
help offset the cost for that the town doesn't have to pay.
Where did the $1 million amount come from? Just curious.
I don't know, was that
Was it based on per person or, you know, occupancy or just curious? I mean, I know it's in engineering.
There was,
It just came.
they were talking about the bid cost, the bid estimates on it, and then the Weston and Sampson, our sewer experts, did an allocation, you know, based on that. I mean, definitely inherent in the HAC decision is contemplating that if it ends up that the gravity line gets built, there should be, that would be the better way to go with the financial contribution. I mean, that's clear in the decision. So I'm hoping that that can be worked out. There's no real reason why it shouldn't be. But I think we need to hear from David more and then Mr. Bracken.
Okay. That just sounds like a little bit of a nightmare to me. Timing, town versus developer, who's answering to who,
And also under.
how much money is in escrow for this? What was that based on? Who's in control of that? That sounds like a huge
mean,
loophole.
Just a final comment
Yeah.
on it. It's not, I don't love it. I
Yeah.
don't love the situation. But one would presume the developer doesn't want to build infrastructure that doesn't make sense. If the town, consistent with the town's master plan, which has spent a lot of time and money and effort on it to have a gravity line, one would assume the timing will be worked out such that that would be the,
Well, I'm just
way to
thinking of
do
the
it.
people living in the units, and when you have a pump station and you're not on gravity, they face the risk of a lot of bad stuff happening. So just for their quality of life, you know, for the people that are gonna end up living there, I'm just curious what the rules are about, you know, switching over from this pump station to gravity. I just feel like it's something that needs to be.
you don't want to be in that situation.
No, you don't. Okay, and I don't know much more than that to talk about it really intelligently, sorry.
I just want to be clear based on what you just said. It's one centralized pump system. It's not individual for any of the buildings. And it'll be designed in accordance with the same requirements that the town has constructed their own pump stations with.
I'm thinking more of the switch over. The switch over and the timing is what makes me a little uneasy
I just
because
don't
it's
think
not
there's any-
defined.
I don't think there's anything we can
It-
do. about
It's,
that.
it's really designed, you could switch over in 15 minutes. That's how it's set up. It's designed for both. So.
Okay. That sounds easy.
Okay.
I doubt it's that easy.
Well, it would block the pipe going to the pump station and it would open up the pipe going to the gravity line, and that's all it is.
Okay.
All right, so, what's the next, line item that anyone has a question on?
It's just everything regarding the public sewer, I think should just be
Yeah,
something that
those are-
we
yeah.
all,
Those are all.
Like fire department, sewer
Yeah.
Yeah,
department,
those
it's
are
got
all-
all kinds. of-
water, want to
Water.
comment.
Yeah,
Those all need feedback.
Yeah.
And so how does that procedurally happen with all the different boards and interfacing?
Usually, I mean, the last time when we did this, they came to the meetings
They'll come to the meetings? Okay.
and we can ask them questions.
Right, because I have all these. Leslie, can you confirm like obviously sewer's working on this, water's working on this, and so whatever these, unless we have a problem
Mhm.
with any of these conditions or questions?
I guess it's just all of our questions right now. I just wonder how they're gonna be dealt with and answered. There's a lot of limbo, non-answers happening because the heads of each department of the town are not here and not participating. And that's when things go bad.
So, through you, Madam Chair, you received comments from David Gray, which were mostly focused on the contribution. I spoke with Mark Willett. He did not provide comments in writing, but he said he reviewed the plans and he's completed his review and doesn't have any further comments at this time. Fire chief provided some comments and he'll be at your next meeting, I think. And we received comments from the building commissioner on the building plans. His review is complete. I'm just going through this in my head, but I think that's all the town departments that was going to review the plans. Town administration
they
has some
don't
of
know
ours.
Right, I was gonna
Sorry.
say, yeah.
So they don't know any of the questions we're talking about today. So this is a whole nother wave of questions
Okay,
for the different.
so I'll
departments.
make sure to request that they come to your next meeting.
Yeah.
Okay.
Only because George had said that there were some things that we had to make sure that, for instance, it was the impervious material that we would note to the building inspector that condition had not been met to our satisfaction. So in essence, those plans shouldn't be approved because they weren't in coordination with this decision or our original decision.
Right,
Right.
but that's sort of stepping ahead to when they apply
Yeah.
for a building permit, like we haven't made it through the process.
Okay, so,
to-
right,
Yeah,
so.
so he just
so
reviewed
Paul was
preliminary.
just reviewing them from the perspective of,
He's just looking at them, what is in front of him, and then we go through all this and then you say to him, hey, by the way, this needs to be changed, so. Like,
okay.
that's why, so we just,
And then when does that show up? How does that show up as a change?
when they do a new set of plans, the developer.
He's gonna do a narrative and he's gonna give you updated plans.
Okay.
Yeah.
His narrative will coordinate with John's narrative. So that we'll have one document.
Mhm.
Yeah, okay.
Okay,
Oh, I don't-
so,
Yeah.
so 69, right, the applicants has to implement this low impact development design.
Oh,
Site
71,
management, 71, the pest management plan.
landscape irrigation being on private wells, not public. 72. You have any
Sorry,
questions?
which one was that?
Well, I don't have a question about it, but just the.
Just like open items of things that need to get done,
Right.
right? Like, do you have, like this, Dawn, are you guys we don't have a site maintenance or integrated pest management plan, right? No, but you're working on, or someone's working on those.
Yeah, someone else is working on that.
Okay. I mean, I meant, when I said you, I don't mean you
Yeah, no,
specifically.
that's fine. I have my others in my list, though.
Yeah,
And Madam Chair, if I can ask through you to Mr. Bracken, I think it would be helpful when they submit this document with their comments. If, for instance, on conditions like this, they comment, not provided now will be provided prior to the issuance of a building permit or prior to the issuance of a
Right.
certificate of occupancy or
Right.
something like that. So
Just-
everyone's clear on the timing of these things and
That's a
when
great
they're
idea.
required.
and yeah, and just for our own, like, when we're going through that, like, we know everyone's on the
Somebody's-
same page
there's a
and someone
filter.
is working on it somewhere and that it's
Yeah, I
it's
love
not
that
gonna fall
idea.
through the cracks. So that would be
Yeah.
great. All right, compliance with state and federal requirements.
Oh, here was number 75 again. No site disturbance shall be permitted pursuant to the decision until the Nantucket Land Council's current pending administrative appeal to the NHESP determination for the site is fully and finally resolved, including exhaustion of court appeals. So obviously that was just thrown out the window because they disturbed the site. So that's frustrating. because I believe their,
I think that's what they're fighting about with the land council.
yeah, their appeals are still active.
And so again, that's, proceeding at their risk. And so if it comes out,
Well, it's not just their, well, yes,
Yeah.
but ultimately it's the risk of what the land council is trying to protect.
Yeah.
Which
Yes.
is, it's,
Well, the one reference there wasn't resolved. Then they're now raising issue about the latest permit. But the one that you referenced originally, that NHESP proceeding is ongoing. We were part of it, with the town at the time. That particular proceeding has been resolved.
was it resolved before they cut the trees?
That, well, yes, that one.
Okay.
Well before.
Is that
They
weird?
cut the trees under was.
well, didn't we talk about this at the beginning, that when we talked about the fences, that was part of
Yeah,
the permit?
don't let
from
me
the
justify
NHGSP?
the tree cutting, but what the developer's position was, the tree cutting was under the final permit that they got from Natural Heritage.
Mhm.
And from a zoning perspective, there wasn't any zoning bylaw that prevented them from doing that site work. So from the town's perspective, they didn't have the ability to go and issue a cease and desist. It was under the state permit that they acted when they did that. And I'm not making a comment on that one way or another, but that's their position. But what I was saying to you from the chair was this, in these conditions, that what you're looking at, that those proceedings were long resolved by the time that we're
Okay,
here now.
that's not an issue.
I have a question for you. What percentage of the questions and the issues that we're talking about are out of our purview, like this particular situation with the tree cutting? Is was that the only thing that we can't do anything about and do a cease and desist, but everything else that's listed here, we could do a cease and desist
Well, it
if they
depends.
break the rules?
Yeah, I mean, it depends on what the issue is.
Okay, that's what
So,
I'm asking, the
all-
percentage. I'm
yeah,
wondering like,
That's
I
hard to
haven't
answer.
figured it out as we're.
It's
yeah.
clear as mud.
I mean,
Yeah.
it's anything that like the ones that are compliant with state and federal requirements, like,
out of our hands.
And it also goes back, remember, you're in the context of review of the final plans for conformance with what's approved.
right.
Okay,
And that is presumably going to be something that the building commissioner then relies on when he is asked to issue a building permit. The ZBA has not confirmed compliance with the final plans. The building inspector would presumably say, can't issue a building permit until we get that resolved.
or
that-
while
that
it's
is
in
kind of-
process, can it be, while it's in process and we're finding that these things aren't being met and it's under development, then it's the building.
It'll be the building commissioner's
Department.
call. I mean, I don't want to
Yep.
speak for him,
Yep.
but that would be my assumption is that,
Gotcha.
and that's what the final plan review is for, is because they're looking at
Mhm.
contemplating applying for a building permit.
Right. Okay, thank you.
Okay, so I think I don't have any, I'm moving on to, does anyone have any question on anything before 86?
No, I'll just make the note that the previous permit was for 206 bedrooms. Versus, what was it, 280 something?
Yeah.
283.
Yeah.
So 77 additional bedrooms.
What are you saying there?
Well, just that it's struck.
Okay.
That's what,
83.
yeah, that's what we had approved.
Mhm.
Great, but no renovations, so,
Right. Okay.
Did you see there's something in 86?
No, I didn't have any questions until that. I just didn't want to jump too far ahead if anybody has any
Mhm.
questions. So.
in 97A, I have a question. It says about a little more than halfway down, it says the applicant must secure board approval prior to construction and allow the board 90 days to review. Is that this board?
Yes.
Yeah.
So if we don't have final plans, how come the 90 days has started?
Yeah.
So these are their final plans subject to the revisions that you require.
And when did the 90 days start?
March
I believe it was
21st.
March
Then why didn't
21st.
we get plans until after?
You,
I just feel like we haven't had 90 days. We won't have 90 days.
the plans came in, I don't have the timeline handy right now, but the plans came in March 21st. You were provided a link to the plans within a week or less than a week. And then you were asked if you wanted paper copies. So you've had the plans available. We've had them in the office since, within a week of them coming in.
Well, I don't know, but the whole thing with the deal with the town came up April. I'm gonna guess 12th or something, or,
No, came up
because I was in California, so that-
April, I mean,
17th.
April
mid-April sometime.
13th.
And if it helps, you
Yeah, April
have
13th
complied
was
with
their
that,
meeting.
because that's what you're doing now.
But we have to
And
have
they're
it,
saying that there's going to be more, so you should obviously you have complied with that. You've
Yeah.
reviewed it within 90 days.
So
You're
but
noting
we
the
have to
issues.
sign the decision within 90 days.
You have to, no, I mean, the developer, I would assume, is going to agree that you have time to complete your review of what they're filing after this meeting.
Okay, I
for a
just
further
wanted to be
meeting.
clear because it was my
They-
understanding that we
Yeah.
only had till June 16th to complete our
Yes.
review and to sign the decision.
Right, and I think that can be agreed to very easily with the developer, like when specifically are they going to get you the final plans and the response to John Chessier's narrative?
And-
And then you could say, when are we going to meet on that? And they could very easily say, yes, that's fine with us, if you're meeting on June 20 or whatever date. Just agree to a date to have it out, because you have done the 90-day review and you noted deficiencies or further questions.
So does
So-
the 90 days start over once we get another plan that is different than the original plan?
In my opinion, no, you're gonna have to just work it out that you did the 90-day review, you noted the deficiencies and the questions. They're gonna respond to that. Because if they went for a building permit now, then you've done the review and you haven't certified compliance.
Here's the rub, and Leslie brought this up in her email to us. We don't make a decision in 90 days. It is what it is. So
They can just do it.
there's no extension.
And-
Playing on that.
Yeah, I mean, I agree with that. I think that it would just be something that would be very easily clarified with the developer. The review will extend out to such and such date. Something very easily to be put in a confirming email, determined in writing with a date certain, a new date certain to complete the review of the updated submissions. That's what I would recommend doing.
What
Because
expect-
it doesn't do the developer any good to say, oh, the 90 days is up.
They'll
Because
just
then they go for
automatically
building
get-
permit and the commissioner says, well, they haven't certified compliance with the final plans.
And they also the developer has a lot of things that they're still working on that they need to submit on, that we've, gone through and noted, and they've noted as well, so.
But they would have to agree to an extension. Is that right?
I would recommend getting it in writing, yes, that the
So
review.
what happened last time is they did not agree to an extension. Okay, so just assume that, okay? Don't
So-
assume. that
But what
we're-
happens when they drag
It's
their
bad
feet
faith.
and not giving us the proper information so that it pushes us to the 90-day
They're good at
deadline
this.
and then
They're-
it
that's
stays
how
as
they
is?
flow.
Yes.
The point is, and I hate to be a heartbeat, but it is now 3:00 and we still are moving through this. So let's just stay focused. if you
I
can.
want to follow up on Lisa's question on this. You got the plans the end of March. You put this on the agenda for April and then we didn't review it. So we lost that, to follow up on your question. It's part of this. You just delay and now we're jammed and we're going to be
We're gonna
jammed
be
some more. So
jammed.
just be aware of that. And if we have to meet 100 times, we're going to have to meet 100 times.
Right.
That's why it's so important for everybody.
But I don't know why we didn't discuss this in April. when it's on the agenda, and agendas are important, right?
The agenda is important. I talked it over with the chairwoman and we had just received the plans. I mean, this is a huge set of plans.
didn't
It's a
know we
very
had to- yeah, that we
complicated
didn't have
document. and
time.
You
Well,
needed time to review them.
I mean,
And it seems like you've had a
Available then in March.
No,
shouldn't
there's
you
no
then
reason.
have
It should be discussed by this board. It
Guys.
should be discussed by the entire board, not just the chairperson. The chairperson is one member of this
We
board.
didn't, I don't remember what the conversation was, and I don't remember why we didn't talk about it, but I
I'll
do
tell you why,
remember-
because the select board was meeting and you guys knew that they were meeting and just decided this. If we need to get this information, we will. So you have
Are
some
you
members of the
saying that
board
I
who are
knew-
doing.
Wait, hold on, hold the phone. You're saying that I knew that the select board was gonna meet about this and that I purposely did not have our board talk about it? I think you need to watch what you're saying.
Why
That is-
wasn't this discussed?
I think because the engineers and everyone was still reviewing and it was premature and would have been a complete waste of time for us to sit and try to do this, as you said, mind numbing task that John did for us, which is taking us 3 hours to go through. together.
Susan, you're
Yeah.
defending this like you have some other agenda. Like, all I want to know,
Jim,
all I want to know, if you want to be on their side and you think that they should
on
take their
whose side?
time in getting us review, then so be it. But we have 90 days. We lost 30 on this.
So I
And-
just need to click,
Get an
wait, hold the phone. Every single one of us got an email with a link to the plans. I sat in my office, clicked on the link and went over the plans.
And we
for a
were ready
long
for the agenda
Did
on the
anyone
April
else see
meeting, but you
it?
had discussions.
So that
Because
was you,
no,
not on the
I
board.
don't, I
If you
mean, I
read
didn't
the
realize that
plans.
was the start of the 90-day until
How
we came
would
to the
you
April.
know?
Well, because we
We
came.
talked
we
about
came-
it.
Why didn't we
The
talk about it in our
April
regularly scheduled April meeting?
It's in the email. You guys, if you're not reading your emails and you are not doing the homework that this board requires outside of the one meeting a month, that is on you.
Well, no, but I did.
I was ready to discuss it in April.
But why
So
didn't we
it
get,
was on me. And why did you make the decision not to?
If it was on the agenda, why didn't you bring it up?
I need to bring it up?
If it was
Okay.
on the agenda.
You're the chair. And so
But if it
there are.
was on the agenda, Jim, I don't recall. I really don't. I'll have to go back and look at it.
I do remember.
Any
there was-
case.
we
And
talked
Leslie,
about-
I don't know why, there was no discussion about, we had the
We're
plans.
asking when the,
It came in.
no, when the 60 days, the 90 days was up and the staff didn't have that information during that.
I asked a specific question because there was confusion
I
about
remember
that, about are we
And
pursuing a
Leslie said
stay?
she
And
was-
Leslie said no comment. So why did you have no comment? Because people knew when we were sitting in this meeting about what was going on. And that's why we did not discuss it.
but that
That
put
is
us,
outrageous.
but that
Madam
is-
Chair, I want to go on the record as saying I strongly object to the characterizations being made by Jim Mandani right now that I would work against this board. That's
I'm not
completely
suggesting that.
insane. And that
I'm
is-
not suggesting that. I am saying, why wasn't this brought up in our April meeting? And why this is important is we have 90 days to review it. And now we're jammed up.
shouldn't
to
we
a
have
40
gotten
day.
a 30-day extension since we did not talk about it at one of the meetings that was part of the 90 days? Shouldn't we
Yeah.
have said? okay,
And
we
Leslie,
didn't
I
discuss
sent
it.
you an email. You never
Just as
responded about it.
procedurally.
So there, why wouldn't you communicate with the board about this?
I did communicate with the board through your chairwoman. That's the proper channel. She sets the agenda. I don't set the agenda. The board doesn't set the agenda. The chairman sets the agenda.
And the agenda
And
was
the
set.
agenda said announcement. I made an announcement that we received the plans and no one raised an objection. We
Okay.
could have scheduled a special
we
meeting
don't
if the
know.
No, no,
chairwoman
no.
wanted
I
to,
mean-
and that's not how it happened. And
Okay,
you're
yeah.
mischaracterizing it.
Here's, I just want to set the record straight here too. In the minutes for Thursday, April 13th, we talked about approval of the minutes for February. Then we had a discussion about Surfside Crossing. Leslie updated the board and the public relative to Surfside Crossing. They've chosen to proceed at their own risk while the hack appeals are still pending. We received the final plan set in the office on March 22nd, and I have distributed those to the applicable town staff for review. And also the engineer for his final review, and that will be scheduled for your May 11th ZBA meeting. It is a 90-day review period, which is outlined in the decision and in the hack decision. So that's the window that you have to work with. What is the 90, Lisa, what is the 90-day date? Leslie, not sure, but it started March 22nd. And I think after that you corrected in an email that it was the 21st. Botticelli, has anybody reviewed the plans? Can I ask questions? And I said, we are just going to do an announcement today. Leslie, what do you think? Leslie said, if the board has questions, that's fine. Because we were just doing the announcement about the status. Lisa says, questioning the letter from Dennis Murphy, have the 25 items in the conditions been received? And Leslie says, comments that we have already received and will receive will be distributed to you on your agenda packet for May 11th. Comments weren't distributed today because they were not a discussion item. And then Lisa said, okay, if you can just update us on the 90-day date. Well, Jim, you said, is the town is in a suit, right? Snell said, currently, yes. Mondani said, is there anything the town is going to do with regard to a stay? And Leslie said, I really can't speak to that. And that, then we went into executive session about the other item, but so everyone had a link to look at the plans. And everyone had a responsibility to look and do their own review. And I said that again at the meeting on April 19th with, I know Lisa, you weren't a part of, but I said in that at the conclusion of that meeting, I said, everyone needs to do their homework and be prepared and review everything that comes into us.
Which is what I did.
But today's the day, sorry.
Yeah.
I know, but I'm saying if we're talking about, if nobody looked at what was given to us to start familiarizing yourself and get prepared, we knew that the engineer was reviewing this. We knew that everything was sent out to town departments and that we were waiting for an onslaught of information that we were going to have to digest and then go through today.
It just feels like there was 6 weeks lost.
Can I just make a suggestion?
I don't think it was lost. I think it was while people were reviewing it. And if we as individuals were also reviewing it so that we would be not just getting this cold and not having familiarity with it. I mean, I requested a copy of the permit from the decision from Hack, the permit that we issued, so I could go through and read them side by side.
There was no forum for us to discuss this until today.
Yeah. Right, I know.
And it was March 21st versus May 11th.
Yeah.
We've had time to review it, yes, but this is our first chance to talk about it as a board.
That's correct, because we didn't have the information from the experts who went through each of these sections.
Mhm.
I don't know how it would.
So wouldn't we want to file an extension since the experts didn't get us this information until now? And we still have questions that need to be answered because like Lisa said, I feel like there's been at least a month lost of the 90 days that we haven't had a chance to collaborate as a board and discuss as a board.
Can I just make a suggestion? Because I agree, but I don't think, Lisa, that you've lost the time. I think you've met, you met publicly on a notice meeting, you started this review. You've gotten the recommendations from the engineer working for the board. The applicant's engineer is specifically represented. He intends to respond to Mr. Chessier's comments, provide updated final plans. I would just make the suggestion immediately following this meeting, we just confirm with the developer when those final plans will be produced to the board, when the narrative will be produced, when the board can meet after that. And we just confirm with them that the plan review is ongoing and will be completed as of such and such a date. And if on the off chance that the developer doesn't agree to that, which I can't imagine why they would, because their engineer is saying he's going to give you updated submissions. But if they don't, then schedule a meeting and issue a document that notes all the deficiencies and the unanswered questions, and that will be your final review. And then the applicant has a situation where they don't have approval from the ZBA, but the final plans comply with the conditions of approval. In my opinion, again, I don't speak for them, but I don't think the building commissioner would issue a building permit in that instance. So I don't anticipate that would happen, but there's no reason to treat it as lost time. I mean, they're representing that they're going to give you updated submissions. Let's just confirm with them when the expectation will be that is the final date to complete the final plan review.
And this doesn't seem out of the ordinary to me from Sagem's Path review or anything. I mean, it's a 90-day review to give the town and the ZBA the time to reach out to experts in each of these sections to give us feedback and then for us to process that. I mean, it doesn't seem like it's out of the realm of what we've done before.
This is just a lot more complicated than a lot of.
This is
other
very
things before.
This is very different than anything.
And that's why we wait, that's why we have the engineer and why we have this, why we asked for this document to show us step by step on
Right.
each condition,
And that's very helpful. I mean,
how everything was so that we can have a
But then-
concise talk about this.
I don't know about the past Sagem's Path, but so once all of these issues get answered by the developer and all of the different departments get a chance to figure out what their questions are, what is the developer's incentive to give us the answers we need before the 90 days is up?
What
To get the
George just
building
said,
permit.
he won't be, and he also won't be in compliance. They won't be in compliance if they haven't met all these conditions that they have to do for sewer, for
Right.
water, for ADA, for the pest inspection or
Okay.
maintenance plan.
So
for
how many times
dumpsters.
before the 90 days is up will the ZBA be able to discuss this?
Well, we'll have to
We have
come
to
up
set
with,
up
we
as
have to
many
set up a
meetings as
meeting
we
schedule.
set.
So it's really the
Special meeting.
onus is gonna be on
On
us
us. Yeah.
to get
okay.
together and spend a lot of
Did
time
we-
doing this.
Okay.
Which,
Unfortunately.
yeah, which is just, that's part of the job.
Yeah, no, I
Yeah.
am.
We're not, nobody's complaining
have
about
no
meeting,
problem.
I think. I
No,
think
but
it's
there's
just-
no
I'll
reason
meet
not to get
every
clarity.
meeting.
There's no reason not to get clarity. We can confirm with them when they'll make the submissions and we'll confirm with them when you're able to meet.
Is it
next
appropriate
after
to do that can we do that through council now?
Sure. Or maybe Mr. Bracken can tell us.
I mean, do you
And
have
then
a-
you can talk about scheduling now. Why don't we do that?
Yeah, we
Do you have an idea of when you think? I mean, you're hearing things from us today, so do you have an idea when you think plans would be able to?
We
be
were,
turned
we
around?
were prepared to submit everything by the end of next week. The only
Okay.
thing that's kind of unknown at this point is what's going to happen with the community building. But we can go ahead and submit everything. You won't have all the details on the community building. You may have the same site plan for the community building under this submission. And obviously, that's going to have to be further discussed
Okay.
with the building. But
And then
by
what,
the end of the next week, we'll have our written response with our plans, including the landscape.
So what would the
Okay.
date for that be? What's
End of next week is-
Today's 11, 12, 19.
yeah, 19th.
And then, so we were gonna try to meet on the 24th, Leslie, was that the day?
I have to check.
Madam Chair, can we also,
Someone had a conflict on the 24th.
can we also ask John how much time he would then need to review
Yeah,
Don's
yeah.
Well,
submission? Because I assume there would have to be a couple day turnaround from that. Ditto, fire, sewer, whomever.
Water.
Yeah, because
That- But each time it should be less and less and less and
Yeah,
less.
yeah,
Because we're,
What plans are you now preparing? John?
The final landscape plans and the civil plans. And the only change I think we have to make on the architectural plans is adding the gutters. And then I'm not sure about the code red response to the fire department. I know they've already addressed internally addressed some of the comments. So I would expect that hopefully they'll have something by that point as well. I think the main thing is like John said, have Mr. Brescher review our civil set and go through our responses. And like I said, I have a few issues that I can talk to John about that we can hopefully resolve before we finalize our set.
So, and when is our next meeting after the 19th?
So last night, if you read your email, I sent one to you asking if you were available next Wednesday, May 18th, or Wednesday, the 24th, or both. And I asked that you email Nikki your availability, and I know some of you did, but some of you
I
didn't.
emailed you, I'm sorry.
Okay.
You emailed all of us.
You
Oh, I did?
So-
Okay, I couldn't remember.
Again,
Makes
please
me
guys,
happy.
try not to
Okay.
reply all.
Well, I thought on a meeting scheduling, that was okay, because it didn't say do not reply all. Sorry,
It did say to reply to Nikki though.
no.
All right. let me select-
So I won't be able to be here at all on the 18th.
Yeah, I have that.
Sorry about
So
that.
you're all set for the 24th. Mark is flexible. He's fine for either date. Susan as well.
Yeah,
Lisa is fine for the 18th, for the 24th, only after 2 p.m. And then Jim, and John, John, what were I think you could do.
I said I could do either one.
Okay, good.
I'm available any of those days.
Okay, thanks.
And our thought on that was we would do Zoom only because there's a lot of constraints with trying to organize having a meeting in this room on short notice.
I think
So if we could do it just maybe for the upcoming meeting, and then when we have more time to arrange the room and arrange NCTV, I mean, there's a lot of moving parts and other boards and commissions that we have to work around.
Well, I think we should start doing, I mean, if we can't do the next one in person, we should plan for one very soon that will be in person, because I think reviewing this stuff in person as a board is very important.
I agree.
I think it is too, but I
Yeah,
was just
so-
trying to expedite it so you could keep moving for at
I don't know
least
how-
the next
So
week.
do we want it? So the 18th is not an option.
I won't be here. I'm
Oh,
sorry.
right. Okay. This is
But
the
the
24th.
24th, can we be in this room in person?
I have to check. I mean, I don't schedule this room. Did
No, right?
Nikki
Wasn't-
check?
I'd have to check. I'll check with Erica. I'll send her an email today and then I'll talk to her tomorrow. in person.
Susan, you board may not want me here, but I can't be here on the 24th. So I just wanted to note that. You know,
And then
maybe I cannot.
Well, you could be in on Zoom, maybe.
No,
offense.
I'm on trial that day.
Oh,
it,
gotcha.
and then what about the little room where they do the HGC meetings at the Plus building?
Yeah, that's a good idea.
I mean, it's not, we're not taking public comments, so there's not.
I mean, it's an option. I'd have to check to see if somebody else will be using it, but if they're not, then we could do theirs.
It's a nice meeting room at the quote unquote ugliest building on the island by the Stop and Shop.
Oh, at the trailer?
Yes.
I'll have to check with Erica.
Well, just let us know. If,
Yeah.
if it can be in a room, we can all be together. That would be great.
I think that makes
And
sense.
If we can't,
And
well, no, because it has to be on NCTV, right? So
Oh,
it
I
has
thought
to
they had the
be-
ability to film it.
it doesn't have to be on NCTV live.
It has to be filmed and then.
We have to be able
right?
to record it and
Right.
post it later.
Right.
But I just confirmed with George that because this is not a public hearing, we don't have to vote on a time, date, and place certain right now.
Oh, good. Okay.
So that gives us even more flexibility to try to schedule something in person for you.
Okay.
But if you could at least maybe agree on a date, that would be fantastic, but you don't have to. Because I know you have other business and we could take that up
Well,
later.
is it a pain to, is it a pain to tell us some availability of rooms and then see if we can, because I'm willing to, I can move stuff around if I need to, if it's gonna make a difference.
And if I'm the only one that's the problem on the 18th, I can see if I can change my 18th, or is that, would that change
No, I could only
everything?
do the afternoon on the 18th.
Okay,
Fine,
I
can
could,
do the
I could,
afternoon on the.
all right, I will cancel and maybe if I'm the only problem, I'll,
Yeah,
Try
we'll
to
see what
fix
the
that.
rooms are.
Okay.
Yeah.
in the Wednesday, the 18th afternoon,
Okay. cool.
Okay, so
And
just to be
George, are you
clear,
Available on the 18th if we need you
a Thursday, that's Thursday, sorry.
next week, right?
Yeah,
Yeah.
it's Thursday. Oh, Thursday I'm available all day. It was the Wednesday I wasn't available. I got confused because of the dates.
I thought so that the plans weren't coming until after that.
Oh,
I mean,
right.
Yeah, but we're not even through our.
I suggest really not trying to jam it in. I mean, is there a big problem with going like the first week in June or something like that?
Well, then we only have 2 weeks.
Matt,
But I mean.
Madam,
Today or?
I can, maybe someone else on the team, maybe Bernie.
Yeah.
Maybe Jamie's on.
Madam Chair, if I
Yes.
may, if we're trying to keep by our 3:30 deadline,
We
I
need to have
don't,
those.
well, I'm gonna say, I
When can we get
don't
through this?
anticipate us finishing the first full review of this, so perhaps
The
the
18th,
18th, we start, we crack down on conditions
That'd be
90,
good.
97 through 154. And so that's knowing that Don's not going to have his plans prepared, but we can at least finish our review, because I'm not sure there's much more from 97 to 154 that would impact Don.
But we'll
Is
have
any,
a
before we
stand-
move on, so I agree, but on 97 to 154, is there anything that anyone,
The only thing I did see is, just, we should have the landscape plans need to be, prepared by somebody that's registered in the Commonwealth of Massachusetts.
what number is that?
97I, I guess. Yes. Accordance with the state building code, whichever requirement is more detailed, others. See what the comprehensive permit, the types, number, size, and location of all trees and shrubs at the time of planting, type of fence and other screening materials. I mean, I just think you should take a look at that condition and make sure you meet it. but I just was noting that it needs to be stamped by a landscape architect.
Yeah, we do have a licensed landscape architect.
Okay,
the
yeah,
stamp
I
on the
didn't, I
plans.
didn't think that I didn't notice the stamp on the landscape plans.
They weren't there originally.
Okay.
And you're already dealing with the, oh, okay, the mailbox, but the dumpsters and all of that.
Yeah.
Correct.
So on Thursday, the 18th afternoon would be ideal.
We could try to get you the landscape
Oh, I
plans
can do one anytime.
a day or two before, if that helps, because
I
I,
really,
That'd be great if we
All right.
could.
Okay,
the
well,
afternoon.
okay. then
I
that's
mean,
fine.
if I have to change it,
Okay, just to be clear, so you guys want it to be in person then, not,
Yes.
okay.
and additionally on the 24th, is that what we're saying? So the 18th and the 24th,
Mhm.
okay?
George isn't available on the 24th, so I'd rather you schedule a time that he can be here.
Oh, right.
Oh, and I don't want to do it on the 25th. 25th doesn't work.
16th.
And maybe Don, one thing to note, I noted that I know we're getting into, it's on page 27. The construction schedule has not been submitted at this time and should be included with the final construction plans. Construction phasing plan developed to address erosion during sedimentation. So maybe a construction schedule?
we did submit one. It wasn't very detailed because we don't have a contract, a site contractor for it yet, and that will be one of our responses, but
Okay.
it's buried in there somewhere. I don't know offhand exactly where it is, but
That's
it could
fine.
be
There's
with the
so much
erosion control
in these
information, but
drawings, it's so hard to
yeah.
see the ball.
Overnight.
Yeah. Oh, and the resident safety plan during construction.
Okay, if we're gonna cover 3:30, was it? Anyone, so, John, do you have anything, before we wrap up today that you want to make sure that you call out to our attention that we may not have got to today?
Yeah, so first off, the 18th, I believe I could be probably Zoom. I mean, for me to come to Nantucket, I can do it, but it adds like hours and hours of time.
I think you're fine on Zoom. Do you guys need him to be here? I think, yeah, Zoom is good.
Okay. There are a few other things further on. One of the things I think that the board should look at, there were some conditions that required profiles and things like that that aren't on the plans currently. And some of that related to the subdivision plan, but some of it didn't because it also included parking lots. And that was not struck by the HAC, and that's a fair bit of work. I'm not sure if they're doing that or not, but often for construction plans, you would have a center line, you'd have radiuses all labeled, you would have a profile of the the main roadway and potentially in the parking areas and things like that. I'm not sure where that sits, if that's something that was being done or not being done. If it's not being done and the board wants it, they should say so.
Yeah, if I could address that. Again, this is not a subdivision road. We would only provide that information if we were doing an actual roadway design. This is more of a site plan. It's not that we couldn't produce that information, but for us, we feel it's unnecessary because we have enough information on the plan to be able to lay it out and to build it. And there's no specific requirement because we're not a subdivision road that under the regulations that say we have to provide all this additional information that we feel is completely unnecessary.
What do you think about that, Jason?
Well, I think it's. I just wonder if, so is there anything that ensures that what's drawn on the schematic plan that the fire chief approves is ultimately what's built for the radiuses of the fire trucks and all that stuff?
Yeah, we
Is
do
there
indicate
nothing-
what all the road radiuses are at the edge of the pavement. And we have provided those plans, or the traffic consultant has, that the fire truck can maneuver through the site. I mean, we have all the geometry, it's in the computer. It's just a matter of adding this additional information that really nobody is going to benefit from. I don't see what the benefit is for us to do all that additional work. Again, it is a site plan, it's not a road. I think
Yeah.
the reason why it may not have been specifically struck is because they just didn't understand maybe what it was and didn't
Well,
strike it.
I mean, it sort of looks like a subdivision, even though it's technically not a subdivision. So
I
the
thought-
idea that they don't have, it's not a subdivision, so you don't have to comply with the subdivision road rules seems a little disingenuous to me.
I don't think so, Lisa. I mean, I've done dozens and dozens of condominium projects that have this type of layout with roads going through it, and I'm sure John's reviewed a lot of them. And this information has never been needed or required to construct the project or to even review it. I don't see what the benefit of having that information is for the review.
Yeah, and I guess, having never had a project like this on Nantucket before, I'm sure those other projects have happened in places where this is more normal, or more, and so this is just a new thing for us, and so,
think-
and it's not our expertise, so I don't rely on John's,
Yeah, I was just gonna go back to John.
yeah, on how he feels on that.
John had, to Lisa's
So-
point.
And sometimes you do, sometimes you don't. I think at a minimum, they certainly should put the center line of the main road in. That takes them limited amount of time in a AutoCAD. With the
We have no
radius.
problem with that.
I mean, as far as the profiles, the reason that you have profiles typically is to make sure that the grades are suitable. This is a pretty flat site, so you don't have steep grades, but you also, it shows if you have something that has, so it drains properly too. So you got enough grade at the low points and the high points to pitch everything. I didn't review the slopes of the roads or anything like that. I mean, it was hard enough to get through these decisions and prepare the document that I did. I haven't looked, I mean, it matched up with what the HAC approved, so I sort of left it like that. Nowadays, I understand construction, they'll have that all listed in a GPS format and they can go stake it out. In the, older days, you would actually stake the road. So you would want to have the center line and be able to stake it out so that somebody could grade to it and understand it. So you would, that's one of the reasons you did profiles initially. It's depends on how it's going to be inspected, I guess, too, as far as things like that, because I do a lot of those. If you go out there and it's just somebody with a GPS mounted on their bulldozer, you really can't check much. You don't have anything to look at. Anyway, so, I mean, there is a benefit to seeing it. It would probably be a bigger benefit to have profiles if it was a more irregular topography, so you don't have something that has a very steep grade. You also just want to make sure that the low spots actually drain to the low spots. I mean, I think this one here, I'd have to check the grades to see what the slopes are. Don, do you know what the minimum slopes are off the top? Yeah.
I think most of the site is 1.5%, but so John, if I may ask John directly, this is a different animal now because if we were designing a road with profiles and stationing and everything else, we would be generating different grades, gutter grades, centerline grades and all that. We don't have a consistent, way of doing that with this plan without going back and doing a substantial amount of work. But I would agree with, I don't disagree. We can easily add the centerline geometry to the plan. If you and I want to discuss any particular issues with the grading, we could probably do that offline and hopefully resolve it before the next meeting.
Okay,
Right,
that
and then we
sounds
can
good.
get
Yeah.
John's comments if he has concerns.
Okay, that sounds good.
The other comment I was just going to make is it does take me some time to look at something like this. I mean, there's a lot of information on the plans to go through. Yes, I have a worksheet now with a list of the things, and a lot of them, it'll be much less time the second time around, but it takes a couple of weeks typically for me to review something like this. It's not.
Should we be asking then for a extension right now?
I'm really glad he mentioned that because I really feel like we're really trying to not necessarily jam it. Maybe you could keep the placeholder if everybody knows that they could make it on the 18th, but if we confirm with the applicant, that we have another date in the meantime, maybe that gives you more flexibility and gives John the time that he needs to give you a meaningful analysis.
That would be the early June.
Yeah. But I mean, the deadline now, as you've calculated, is June 16.
Yeah.
So if we confer with the developer and we say, well, the board may need 2 meetings. So let's extend it out to June 30.
Can we,
You know, is there,
is council still on? Yeah, so can you let him in so we can talk about that? If
Attorney Haverty,
Good afternoon.
Hi, we're just well, you've been listening, but we're just talking about, turning plans around and getting, another review, and if, for timing wise, Chessie is saying he needs typically about 2 weeks, and we're just trying to do the time, hoping that you guys would be open to a discussion of, extension of the 90 days for review, to give us a chance to review what comes back from your submissions and our engineers' review.
to complete the review,
Yeah,
complete the review by June 30.
yeah.
I'm in a difficult position here in that I've missed most of your meeting on this because I had to go over to the Zoom meeting on the Superior Court. What I will say is that you've got another meeting that's scheduled before the expiration of the 90-day period. I will consult with my clients, try to get brought up to date as to what has occurred so far, and we can certainly provide you a response at that meeting.
Okay. And I would just ask also that if you maybe include Don in that bracket, in that conversation, since he's been here, and
Yep.
we'll have a good, I think, a good handle on our requests and obviously what he's working on and whether our request is reasonable.
Yep. No, we will meet with all of the members of the team and go over the responses.
And I'm happy to discuss that with you as well, Paul, on the.
Appreciate it. Thank you, George.
Pardon me. Okay. So
what if they don't give us?
So
the
wait,
extension?
before we move on to that, then they don't give us an extension. But before we move on to that, so we're talking about doing this meeting on the 18th. We probably won't have plans, although Don says maybe we'll have a landscape plan. Do we want to meet then, or do we want to wait until we get
We want to go through the rest of these conditions.
and meet then? Okay, I just wanted to, because I don't feel like that's rushing or whatever to meet on the 18th. I think that would be meaningful.
That's fine, because we won't have his plans. We'll
We'll
go
finish
through
what we
this,
didn't do
and then
today.
we'll have to meet again once we get the final plans,
Right,
and
so that-
John has,
So we can do the 20.
well, we won't have
have
John's
John's, so
comments.
right after that. Okay.
And then it's Memorial Day, and then, so.
And Madam Chair, even if you don't have plans, maybe you'll have responses to some of the questions
Right.
and concerns that you raised.
Yeah,
So
I
we'll
mean-
give you some time to talk about those.
On the 18th or the 24th, you mean?
No, from the departments.
Yeah.
Yeah.
Yeah, there's other things. Okay.
But I don't want to avoid my question
Sorry.
of what if they don't agree with the extension to say June 30th?
Then we send the building inspector something that says that they haven't met the requirements.
So we deny,
We don't deny.
We
just
deny.
say-
We
What if
just, we're
we're
not,
not in approval
what's the
of.
language? We're not certifying
that they've
the
met
plan. Yeah.
That's
It's always
building-
nice to know what the consequences are before.
So you
you-
shouldn't be able to get a building. permit.
Yeah.
Yeah.
So it would behoove them to agree.
Yes.
It really, I mean, let's. I'll meet reality too. It would benefit everybody if John Chesia has a reasonable amount of time, considering his other commitments, to really look at this for the board.
Yeah.
You know, he's the best. So we want to make sure he has enough time. So however you have to do it, if you have to end up that you have to rush and make the decision by the 16th, so be it. But hopefully the developer will agree, John will have enough time, and you'll have enough breathing room in June to complete your review and finish it by the 30th.
And I also want to make a priority meeting with the select board.
Absolutely.
You know,
All right, so we want to, do we need to,
Make a motion to
how
continue.
do we, well, is it, do we make a motion to continue for this? We don't have to do a time and date certain, you
You
said,
don't have to do time and date certain.
so just a motion to continue.
I'll make that motion.
Second. Okay,
Should we try to incorporate the select board in our 18th meeting?
I don't know. I don't know.
No,
I have
okay,
to-
we'll wait
it's
till
too
at the
early.
end of
I-
it.
I would just suggest it's a very different discussion
Yeah.
and maybe that should be done
Yeah,
separately.
I think we have a lot on our plate for the 18th just for this.
Mm.
I don't want
Yeah,
to, I don't want to,
okay.
I don't want to
Yeah.
I don't want to dilute away
Well,
from
yeah,
this.
gotcha.
I think that
Madam Chair, do we need to roll call vote or?
I'm going to do.
Oh, sorry.
Yeah. So, again, I guess I'll just stick with I'll stick with the members, the full members. So to motion to continue, myself, Lisa,
Aye.
Elisa,
Aye.
Michael,
Aye.
and John Brush.
Aye.
Sorry, when I said yours. All right, so we'll take this up on the 18th. And we'll move on now to, so,
Madam Chair, can I make a request on this? On the voting members? I think it's more important, appropriate to have members that sat on this, vote on this instead of others, so. With that, I think it should be for consideration. I think even Mark, did you,
do you,
you
did
attended
sit on this?
the
I can't- I
hearings,
couldn't
right?
remember.
You know, unfortunately, I was away early on in the process.
Yeah.
When it first came up,
Yeah,
and I have not sat in or spoken about this in any fashion except for today. So I would agree with Jim, if that's acceptable, that you know, I just basically be quiet on the matter here. I mean, I've done all the homework.
yeah.
I know how to read the plans.
I think your input would be valuable because it doesn't, I don't think it matters so much about not sitting on, I mean, I agree, Jim, like.
I'm talking about votes.
Yeah, yeah.
Yeah, I
agree
still
that
think you should be.
I agree. You, me and Lisa, we did sit on this application, so that. we-
I do agree, I concur with
Yeah.
that statement.
But I think for the review and the review of the conditions, you bring a lot to the table
Yeah.
for this kind of thing, and I would appreciate your input.
Hey, happy
Yeah.
to attend.
I'd just like to suggest that you leave it open because you do have a tight window. And if someone can't make a meeting or were to become ill or something and couldn't vote, you need the flexibility to be able to pick your 5 voting members
At the time.
at the time. Yeah.
Okay, so are we moving on?
So we are gonna move on to, get out of it. We are in executive session for this one, so we're gonna
Oh,
move
wait.
to executive.
So
session.
I leave, but so I won't be back for on the bill bar and.
No, you'll come back. We're just gonna, or you're leaving.
Can we do those first?
No, we're doing this litigation one first. So
And Madam
Leslie's-
Chair, just let the record reflect, I'm recused
Yeah, you're
on that
out.
matter and I'm leaving.
Lisa's out. And John's out,
Wait, hold on. Is this?
but you're coming back.
Yeah.
Okay.
Madam Chair,
This is not executive session.
correct.
Oh, okay, it's not, right? Okay, I didn't think it was. Okay. All right.
That was being misstated.
What? Right, okay, that's what I thought, right, we're just not taking, sorry, my agenda like went on the floor somewhere. So we're just, okay, go to the ladies' room.
So should I not?
So Leslie's.
Madam
recused.
Chair, can you hear me? This is Alex from.
Hey, Alex, yep, I can hear you.
How are you?
Sorry.
No worries. Yeah, as you had mentioned, this is just going to be a public meeting, so the board will not be accepting public testimony or any
Right.
new documentation. We're just going to have a discussion amongst ourselves regarding the one issue that was raised for remand.
Right, did you have a chance to draft this sample language for us or?
I unfortunately have not
Okay.
gotten around to that yet, but I have a proposal in terms of what I think would make sense and is consistent with the prior discussions we've had.
Okay, I
so
think
just
we have to wait, hold on one second. I think we have to wait for Elisa to come back because we've got 1, 2, 3, 4.
I shouldn't.
If you, then you should go out. Yeah, then you should leave. Yeah, I mean, sorry to be that sad, get out. Yeah, to be safe. Just, if you see Elisa out there, will you send her back? Oh, good.
You were on the original decision. Madam Chair, may I have for?
Yeah. You what? That's the start. Hold on, let me take this off.
Well, I don't think so. You have to do cards. Well, we're not doing executive session. That was in this. That was in this.
No, I meant that. That application.
Okay,
And do you have a copy of that?
Yes, we have.
can we jump ahead to it? Oh,
So we
We're going
can,
to go forward with that.
yeah, but we can also, if we go 4:30, we probably just do it a little bit. I know. What time does it start? Oh.
I'm here. Oh, it's a long game. Planning to just.
Okay, lacrosse is long.
Lacrosse can be.
Okay, so we're all here now, right? Okay, so, Alex, you can go ahead. Thank you for your patience.
Oh, great. Thank you, Madam Chair. Thank you, members of the board. Alex Whiteside from KP Law. Appreciate everyone taking the time to go through this remand process. As you may recall from when we last spoke, this matter relates back to a special permit that the board had issued. I believe it was back in 2021 for an extension alteration of a pre-existing non-conforming single-family dwelling on the property owned by Mr. Metz, located at 14 Western Avenue. Following a land court trial before Judge VIII, the court ordered a limited remand back to the board to consider a particular question and interpretation of certain terminology in the zoning bylaw. In particular, the question for us to discuss and consider today is, at the time that the applicant, Mr. Metz, applied for a special permit for the renovations to the dwelling, had the existing dwelling been in a condition for 3 or more years after November 2nd of 2016, such that it could not be used as a dwelling unit. And looking at the definition in the zoning bylaw of dwelling unit, dwelling unit is defined as a room or enclosed floor space used, or to be used comma, as a habitable unit for one family or household, comma, with facilities for sleeping, cooking, and sanitation. And I believe, as we had discussed last time, the board's interpretation of the definition of dwelling unit does not necessarily require actual habitation of the structure in order for the structure to maintain its pre-existing non-conforming status, but rather that the structure, at least with regard to a single family dwelling, is actually in existence as a structure on the property and has facilities for sleeping, cooking, and sanitation. So, bedroom, bathroom, kitchen, and, whether or not it is currently being inhabited through future permitting efforts could be capable of habitation. So, I think the question is, with regard to the Mets property, at the time that, so in 20, as of November 2nd, 2016, did the structure on the property have, bedrooms, bathrooms, and a kitchen, and were efforts being made such that the board could determine that, through permitting efforts, which he was undertaking at the time, that the dwelling could be used after permitting as a habitable unit. So,
Alex?
yeah, please go ahead and give me your
Okay.
interpretation.
So, I follow you and agree. However, I'm concerned about adding any language that says making efforts or through the permitting process, because the zoning district it is in, a residential use is allowed by right. So whether it's a structure that's been there since 1842, or whether it's a structure that's been there since 2020, or whether it's a vacant lot, or whether it currently has a auto body garage repair store on it that's been there before zoning came in, it is allowed to be used as a residential unit. So the dwelling unit doesn't lose the ability to be a dwelling unit, even if it's not being lived in year round or half-time or part-time or anytime. So I think we just and the rest of the board can chime in on this too, but I think we may just want to stick with that definition. Hold on, I can't find it.
Just, Madam Chair, if I could just chime in, just to take a broader interpretation to say that simply the structure being located there and being in physical existence on the property.
Yeah, I mean, the bylaw says to be or used or to be used, so I think it's because the only reason we need to discuss this is because it wasn't discussed in the public hearing originally, because it's sort of like an assumption of fact.
Correct.
Right? Like.
Yep. That's correct.
If it was a commercially zoned district,
it was brought up in connection with the trial, the issue of whether or not the use was abandoned because no one has been living there since I think the late 90s.
Right. And Paul Murphy's here. Do you want him to speak to that at all? Or did you speak last time, Paul? I can't remember. No. Do you want to just, we'll go to the mic. Sorry. I mean, do you agree with what?
What are you referring to then?
I'm referring to, the stuff that we had, this is my notes from last meeting.
Oh, okay. The language. I was just wondering.
Oh, the language, sorry, is section 139(2) was the definition of a dwelling unit that's says enclosed floor space used or to be used as a habitable unit for a family or household with facilities, et cetera, et cetera, et cetera.
Paul Murphy, Building Commissioner. So my position on this is a conforming use in a residential zone. It's a single family dwelling. And it doesn't matter that it's maybe dimensionally non-conforming, but it's an allowed use in a residential zone. It can be, it doesn't lose its use whether it's occupied or unoccupied because it's permitted, period. So that's my position on it.
Okay, so Alex,
Thank you, Paul.
for us today, you need us to support the building commissioner's position or make a motion?
Well, it's the Judge Vey ordered that the board issue essentially a new special permit decision that
Right.
includes or addresses this particular issue of the interpretation of dwelling unit. So I would recommend that first that the board reach agreement in terms of the interpretation. If everyone is on board with the interpretation that you, Madam Chair, and that Mr. Murphy has provided, I'm perfectly comfortable, and I think that's a reasonable interpretation. And I'm happy to put that into a decision for the board to sign off on, or even, Madam Chair, for purposes of expediting things, I think we could just have you sign off on it on behalf of the board. But I think a first step would be for the board to agree on that interpretation, and if so, then vote to issue a special permit for all the reasons the initial special permit was issued, as well as and including the interpretation of dwelling unit as we've discussed.
Madam Chair,
Yes,
unless the board wants to spend more time on discussing this, I would be willing to make that motion.
okay,
I second it.
and Jim seconds, okay. So the motion is that we're gonna issue a new special permit with the conditions that we had, plus language interpreting or including Paul Murphy's interpretation, and the board agrees with that interpretation of 139. What did I say? 139.33.2, was it? I don't remember now. And does everyone want to sign, or do you want to authorize me to just sign it? Everyone can look at it. We'll have.
Is that part of the motion? I'll amend it, Michael, for
Yeah,
Susan.
and I mean,
Susan
I think it can be written by our attorney and passed under everyone's nose, but I don't want to spend too much time on it.
Yeah, okay.
So
Is that included in your motion, Michael?
That is.
Okay, okay. All right, so we'll do a roll call vote then. Mark?
Aye.
Elisa?
Aye.
Michael?
Aye.
1, 2, 3, and Jim?
aye.
2, 3, 4, and myself, aye. Okay.
Thank you, everyone. So, Madam Chair, should I draft a decision such that you're going to sign it, or is the whole?
No, you can do it so that I'll sign it, and staff will email it to everybody to review before I do anything.
Excellent. Okay, thank you.
Okay. Okay,
That's great. Thanks, everyone. Appreciate your
Okay.
time.
Thanks, Alex.
All right, take care.
Billy, do you want to grab whoever's outside and we'll just go to bank? Yeah.
Yeah.
Because we've got 33 minutes or so. Oh, yeah, Leslie had to go right at 4. Okay, okay. So. Okay, so we're gonna move on to old business now, 37-21, Kristina and Nicholas Amendolare, 8 Bank Street, Attorney Mike Wilson is here representing. We have a draft decision with conditions to review. A new revised edition came out, which now, of course, I can't put my hand in.
Hold on.
Oh, wait, no, I have it here.
I'm not sure which one is.
Folder. Different folder.
Oh, I had one note too.
This one has red line on it
Mhm.
showing the changes.
I just wanted to make well, I don't know what we're gonna say.
Okay, so
Email.
I
to you.
just got the red line one and have not.
Oh, I looked
read
at it
it
online.
over
I don't have a
the
copy of it.
changes.
so okay.
Okay. Attorney Wilson, did you have any issues, or have you seen the latest one with the red line changes?
For the record, Madam Chair, Michael Wilson for your applicants. I have, thank you. I received it yesterday. I see it as real cleanup housekeeping more than anything substantive from the initial draft that we saw. I've reviewed it with my clients, ask you to adopt it.
Did anyone, and Lisa, you had? a
I had one
question?
change. I think in 3, the statement, the health department submitted an opinion that a second bedroom would not be possible due to the site restrictions and a full foundation within the prescribed distance to the septic tank would be a violation. I think that should read finished basement. Because my recollection is that the information that was submitted was that the basement, doing the finished basement was not possible given the location of the septic tank. And I still concur that that will trip needing to upgrade the septic system, which is not a viable alternative.
I'm sorry, where is this?
Item 3. It's the last sentence in
The
3.
health department submitted an opinion that a second bedroom would not be possible due to site restrictions. Oh, it also, no, it was specific to it said basement.
Yeah, full basement, finished, or full,
Yeah.
a basement. Doesn't even have to say finished basement.
Yeah, that it was just a basement,
Yes.
and I have that here.
This is 6 like crossing. Billy had dropped other decisions. Oh,
I don't
item.
even think it needs to say finished. I just think it needs to say
The basement.
basement.
Okay, so right there, it says the health department submitted opinion that a second bedroom, it should say opinion that a full basement would not be possible.
Okay.
Could I suggest, Madam Chair, that it just say that the health department submitted an opinion with the date and it speaks for itself?
Why?
Because I don't see it now and we're going on a memory. So if it says that,
She has it.
so
Keep all my notes and all my little highlights.
That's why she's the best chairman in the world.
Well, let's see. Well, just because I forget, there's so much stuff, and if you keep, I
mean, will we not satisfy both if we attach it also as an exhibit?
just think it's.
I can say it speaks for itself and then you satisfy
Well,
the
but
health
still keep
department
that.
and the board.
Um,
Hold on, I'm just looking for
Do
the
the site
words. I just want to
restriction.
make sure that we say it correctly. It says the construction to install a full basement is new construction, therefore will not comply with the setbacks of the septic tank and leach facility. This is new construction from a previously approved maximum feasible compliance situation. The approved variance was only to allow the property owner to maintain the cottage on the lot, not to allow for new construction. So I don't even think we need to say basement. I think we can just say no new construction. Well, all right, no, don't say that.
Would not comply with, should it just say the full basement would not comply, would not be possible due to site restrictions and would not comply with Board of Health regulations?
I would say it would violate, I just would say it would violate the approved, the health department variance.
yeah, related to that, and we have septic tank. This to septic tank will be a violation. What's it a violation of? Is it,
It's the,
I think we either specify or refer to
where are you saying that?
at the very end of the sentence.
So the health department submitted an opinion that would not be possible due to site restrictions. Would be a violation of the of the the variance.
Madam Chair, could you incorporate that health department letter? And that way you just need to reference the health department's
Attached. to the
submitted, dated, so that you know specifically what it is, attached here too, so that you're not rewriting what the health department wrote.
It just said the
Just
health
say-
department submitted an opinion that a full basement would not be possible due to site restrictions. Period. Refer to health department letter, blah, 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 blah.
Attached. All
Are we
right,
voting in the words full?
okay. Yeah, we'll attach the health department letter dated 1/19/23 as an exhibit, and we can say,
It speaks for itself.
yeah, the health department's been an opinion that a full basement would buy just. Yeah, the health department submitted a letter dated 1/19/23 attached here to stating that a full basement would violate the existing variance.
Does it define what full means?
No.
How deep?
No, it doesn't.
Well, then I just think we just put the word basement in, because what if they want to
It
put in a
doesn't matter,
6 inch,
'cause the le-
6 foot crawl space?
Could it, what is the wording of that opinion? Sorry.
This says the variance was granted due to existing conditions on this lot. The construction to install a full basement is new construction, therefore will not comply with the setbacks of the septic tank and leach facility. This is new construction from a previously approved maximum feasible compliance situation.
Right.
The approved variance previously was to allow the property owner to maintain the cottage on the lot, not allow for new construction. Any work to the foundation of the house will affect the structural integrity of the septic tank. So I think we just have to say why don't we just say any foundation.
Any new foundational work?
Health department's been an opinion dated 1/19/2023,
Attached here too.
attached here to stating that any new construction of a basement and any work to the foundation is in violation of the variance.
That's not correct.
Then just say,
As more fully set forth therein.
yeah,
Okay, let's go again. So the
Ah.
health department submitted an opinion dated 1/19/23 attached here to.
And incorporated herein by reference would accomplish the goal.
Submitted a letter of opinion.
That way you're not rewriting what your health department wrote to
Right.
you. You're just
Yeah.
saying this is what the health
Yep,
department stated.
yeah, incorporated, okay. Do you guys feel comfortable with that? I know, but there's still. Yeah,
Are there
we can
any other
still talk about it.
references? Are there any other references to a full basement in this? Or basement or full basement?
In the decision?
Mhm.
Okay, so take out would not be possible, violation, right?
Well, that's what I was
I mean,
wondering,
it's not-
if there should be more discussion about the McCarl drawings and what they should be.
I would just suggest typing attached and incorporated herein by reference, and that takes verbatim the health department's language into your
Yeah.
decision.
And that the health department issued.
Putting
Issued, that's
fo-
great.
Basement foundation.
Yeah, because otherwise other than quoting and saying exactly what they say, it doesn't make
Right.
sense for us to rewrite it.
Yeah, it does say later about that only one bedroom is proposed unless the property is connected to public sewer or approved for additional bedrooms by the Board of Health.
Mhm.
Or that should probably say approved for new construction by the Board of Health. I guess. I don't know.
You could say
You should put some reference.
to that end
Or like
support it, like the.
regarding the previous sentence or previous. You know, I just think
Yeah, you're right.
it's kind of sitting out there.
Stating that
Regarding,
no
you
new
say
construction.
regarding the septic. Like at the beginning, instead of the health department, like. Oh. Like.
Issued.
Sorry,
Yeah, the health department addressed septic issues in a letter dated that attached here to incorporated by reference. Does that sound better?
Kind of implies there are other issues.
Well, we're
It's
talking
kind
about-
of tied to the previous sentence, right?
Right.
Or addressing the foregoing
Yeah.
We
restrictions
should say to that end or in some. Where?
to that end.
Before the health
Before
department.
the health department.
Yeah.
Or like. to that end, but,
Accordingly.
Accordingly, the health department submitted
Yeah.
a letter dated 1/19.
on right, pardon the comment. Hard to do real time, isn't it? No,
Regarding that issue.
I reference, just say addressing septic. Addressing the existing septic variance and. Okay, after one minute, after here. Oh, by reference, okay. Right?
Yeah, addressing the issue. And they're, or stating their opinion or whatever.
Addressing,
The foregoing something.
addressing the septic tank and existing variance.
Was it an opinion letter? Or just
Yeah.
Can I add one thing? Septic tank and leach fields, because they're both are mentioned in the opinion. If you're gonna say septic tank.
Michael, how does that look to you?
I would just
replace it. Something.
Addressing the septic tank and period. Is it addressing
It mentioned that-
variances? Because they're not really
It did
looking for a
mention-
variance and,
It did mention the
just say
variance.
existing
but we're not
BOH.
asking for a variance. So why would you put
Existing
variance in
BOH.
there?
Say, existing BOH variance.
The septic system does.
It says right here that the Board of Health.
Right, I think this is a zoning opinion. I don't know why you'd put the word variance in a zoning opinion when we're not asking for a variance.
So maybe we just
It
did,
says the Board of Health granted a variance.
Yes, it said a lot of things in that letter and you could make it very clear by just incorporating the letter verbatim. And that way you're not rewriting the opinion of the health department and we're not trying to come up with language that the health department already came up with. Addressing the septic tank.
couldn't it just say incorporated herein by reference, addressing
could.
the septic tank and leach fields, period.
If that's what,
I
yeah,
would put in leach fields though, because they do mention that they're also going to be in danger.
Yeah, I don't think the Board of Health addressed it. I think the Health Department did.
Oh, sorry, Health Department. I'm sorry. You're right.
LEACH. Right?
Yes.
That's one of those ones.
Which kind of leach are we talking about?
LE?
I think that's the kind that sucks blood.
Yeah, that's the.
Oh. I would have.
I just, yeah, LEACH.
We,
Okay.
we can clean up
Yeah.
grammatical errors after this too.
Okay.
Okay, so does anyone,
singular, not plural.
so these conditions,
You're
were modeled after another decision that we did for, Kite Lane. I have that decision, if anybody wants to look at it. To see what
Yeah,
we did, but
so-
they're very similar.
And I had just one, there's one other mention of the septic system. I don't know if it's a big deal. It's in the bottom of 5. Only one bedroom is proposed unless the property is connected to public sewer or approved for additional bedrooms by the Board of Health. I would just change for additional bedrooms.
What? I have it, yeah.
Since that's no longer applicable.
Right, all thorough inspection of the road has been done and will be monitored during construction well, it is, they're still,
Just say, or
they're still going for the new foundation.
just say only one bedroom is proposed. If you have a problem with it, couldn't we just
They're
say?
asking for the new foundation, whether or not they get Board of Health approval to do it, or they tie to they want the foundation. So that, I think the foundation statements.
Okay, so, or approved, or approved.
I mean,
or-
this,
or
new foundation has to stay in the decision. Doesn't
What,
mean to
what are you
approve.
referring to?
Where are you saying? Where-
Oh,
Bottom of
right,
5.
Bottom of 5.
Oh, yeah, I also, there's an or in there. Is that because if,
Well, say
if
connected-
there's not a public sewer, or if there's a public sewer, do they still have to go to the Board of Health?
You never know with expanding technology, whether you
They go
can
to-
satisfy
they
the
should have
Board of
been
Health
sewer
with the
department.
alternative
So I think
system.
it should be and then, right?
Well, it's or the go connect to public sewer, in which case they have to go through the health department to get their, no. The sewer department, to get your sewer entry. fee.
Right.
And then, the only thing that I was saying is that I think we're not, they're not restricted, they're restricted by the Board of Health per that letter for any new construction of a full basement or a finished basement. So maybe that shouldn't be, maybe that should just be taken out. Only-
Yeah.
Maybe get rid of that whole sentence.
I would
'cause we're
just
already-
say connected to public sewer. Only one bedroom is proposed unless the property is connected to public sewer.
And all approvals required by the health department are obtained.
Yeah, I know.
Right? So I don't like.
Can the zoning board condition another board? That
No, I
just
think it
commenting
just-
on that
Oh.
Oxford language,
I think we just say unless it's connected to public sewer, because that's how it is at
unless
this.
approved by the Board of Health. Because they might have a different criteria than what we're contemplating here today.
Won't be approved by the Board of Health,
I understand.
No, I'm just saying only one bedroom is proposed unless the property,
something happens.
unless
Unless
something
they get it
additional is
approved.
approved by the Board of Health.
Because
Right.
remember, they didn't go through the Board of Health yet.
Right.
And I think this is saying
Oh.
But they
that
did,
they could.
they
get
could
an
also get to
additional
public
rep-
sewer, so it should say or connected to public sewer or approved by the Board of Health. They should both be in there. But not for additional bedrooms.
Yeah, just take out 4 additional bedrooms, just say or
Yeah.
approved by the Board of Health, and then we're.
Thank you.
Then we're done.
Thank you, Ms. Botticelli.
That's a discussion.
Just to clarify, so it's, you can automatically add additional bedrooms once you're connected to the public sewer.
Yes,
Yeah.
Okay.
at the moment, there's no sewer moratorium. There was at one point, but
Or a fee.
for a small fee
Right, right.
of $6,000.
Okay, so did anyone have,
So I just had a question of why there's no reference to all the McCardle documents that we actually went through. The bottom of the top, where the slab, the height of the slab, all that stuff that was extensively discussed isn't part of the decision.
Linda, you have to come to the microphone if you
I thought
want to
we were taking
comment,
public
and
comment.
I had the same question because the Kite Hill decision was extremely detailed about all of that stuff. And I didn't know when I read if that was, and since the decision, Billy, I guess this question is for you, because the decision was based off of Kite Hill, or at least the conditions. Was there a reason that all of that other detail wasn't included? I didn't know if that was just a drafting preference on Eleanor's part, or.
No, I mean, from my understanding of kind of learning this stuff through Leslie, I don't know that you have to be super detailed because that information is in the minutes of the meeting.
And it's on file in your
Can you
big
identify
file.
yourself?
Linda Williams for the applicant as well. It's on file. I've done probably 3,000 decisions. And normally that kind of detail is not in the decision because all that information's in the file. It was represented in the minutes and on the video record. So basically, the letter that you just mentioned from the health department should be Exhibit B because Exhibit A is the site plan. Just to keep it consistent, if you're going to attach it.
we discussed where you're gonna locate the house. While you're lifting it, does that need to be addressed here, or am I missing something?
I thought-
In zoning compliance.
Okay,
Yeah.
so there is a methodology that, okay, or a restriction.
They
And
do
it'll,
have-
it'll be taken back off-site, more than likely in order to get underneath it,
Right, are you talking about all this?
which is outside the property
I mean, I
lines.
just didn't know. It just
Okay,
seemed like we
because
were
the
talking about all
neighbors
this stuff.
expressed concern about it blocking things. Is that
Yeah.
gonna be?
We have to get a road closing permit when I do move it. So there's a bunch of other things that have to take place with the town on that one.
So for, like, when we did Kite Hill, we had the construction methodology for, as Exhibit B. And we had detail about the measures, about how the foundation was gonna be done. No vibrating, no exterior sheet pile, like all the stuff that we talked about and agreed to in the course of the hearings. And that, I didn't know if that was, yeah, because it needs to be included, I think, for the, well, I think for the neighbors and for.
Right, and I think one
With
of the
Exhibit
reasons
C,
is,
which is
because-
McCardle's thing. I
Well-
mean, for the engineer's letter, the last one, you can put that in as Exhibit C if you wanted to attach that. Because that's where he went into the methodology.
Isn't that in
Yes.
paragraph 5?
No,
No, do you, here, can you come up, can you approach and I'll show
Yes.
you what I'm looking at? So when we did this for Kite, pardon me, Kite Hill, we had this attached that had just basically all these things that were discussed,
Everything that we proposed.
I guess, yeah.
Incorporate Wayne's proposal for what the applicants.
something in that format would be helpful, I think.
Yeah.
right? Since we started the discussion with them doing something that was going to vibrate and then we ended up with the piers, I just think it has to be, yeah,
Drive drilling.
yeah, the piles, excuse me. I think it should just be specific. Mhm.
So
Material submitted into the file, or do you want to attach McCardle's last letter?
I'd have to
Let
look
me
at the
see if I
letter.
have it.
Let's see, I have,
Because he was very specific about not doing, the vibration is going to be minimal because they're changing the methodology and how they're setting the house on.
I don't think I have it.
I have it somewhere.
I think it was in your packet last time or the one right before that one.
Okay, I think it's this one. Hold on. Is it geotechnical engineering report dated May 5th?
That should be it. That's McCardle's letter.
Yeah,
Okay.
so we want to just put that as an Exhibit C. I mean, I know it's long, but that way we don't have to someone doesn't have to type up this.
Is that the May 5th one?
Mhm.
Is that the right one?
Well,
Just want to
and
confirm that's the one that the board is comfortable with.
That who?
Your board?
Oh, sorry, I thought you said someone Boyd. I'm like, I don't know who that is.
Been a long day.
It has been a
well,
long day.
and then they also mentioned the Kite Hill, the project shall be done in conformance, in accordance with the construction methodology engineering plans attached herewith as Exhibit B.
Mhm.
I don't see that here. For the construction. So measuring and supervising.
Well. Okay, well, do we want to just see if you agree to these ones in addition here? And we can add those, like the ones that says. In addition, there'll be no vibrating of sheet or shoring materials. There'll be no exterior sheet piling, the exterior dimension of the foundation. Well, that doesn't matter.
If that's Kite Hill, I wouldn't want to incorporate that as drafted. It would just reference how Mr. McCardle proposed this project
Right.
construction methodology.
And this is the most recent one we have. From him. I
Yeah,
don't know, I'd
May
have to-
5th
I'd
was
have
his
to go
last
back and
one.
Read it.
And it was the last presentation he had given the board at the
Yep.
April meeting. which by all accounts satisfied the board because you closed the public hearing, taking in any additional information about what the construction methodology would
So
be.
like this is. Right, so this is what I had asked about on page of our packet last last month. Oh my God, I'm losing. The pre-construction surveys, I think I had asked you that question, Billy. And here it says they offered to the 8, what I had said, was it gonna be adjacent properties or how was that to be determined? And this says the homeowners offered to the 8 adjacent properties and then listed the properties and pre-construction surveys performed to document conditions interior exterior.
Are you reading from Kite Hill?
No, this is from
Okay.
your clients. So I wanted that included in.
It's, I think I put it in there as one of those conditions about the pre-construction survey
It's not in there.
for those who wanted to do it.
Yeah, I don't think it's in the final decision.
It should be,
I will,
Letter D of the conditions on that decision.
yeah.
oh,
It says, and to any neighbors upon request.
Yeah, Leslie added that upon
That's all-
request.
That's
no, that's
contact information. We're
I'm talking
looking
about
for.
pre-construction surveys.
It was in there. I don't know what happened to
Yeah,
it.
it's not in there, cause I had that caption.
It may have gotten lost when they redid that one paragraph.
I don't think so, cause that was a question I had on the original one, but maybe, who knows?
We're gonna get bumped out of here.
Sorry,
Maybe-
it's further up, number 5. It says a survey of the surrounding structures will be done as a portion.
I think the word pre-construction is missing.
Yeah,
That can be added.
we can easily add it in.
Pre-construction surveys, of the surrounding structure will be done.
Yeah.
As a portion. Yeah, then we gotta get out of here.
Madam Chair, that same language you can use there, pre-construction surveys for those who request it. Because not everybody's going to want a pre-construction survey. So if you put down pre-construction survey for those who request it, that should do it.
Well, it does say a survey of the surrounding structures will be done in the middle of paragraph 5, page 2.
Yeah. I just forgot the word pre-construction.
Okay.
A pre-construction survey.
Yeah.
Add that word. That's good for the board,
I
although
think so.
it's rather implied because why
Right
would
there,
we do a
Nicola.
post-construction survey?
Right.
It's really to protect my clients from any claims of liability. So.
Yeah.
I think pre-construction just,
Is there anything about a bond or
Helpful.
anything too? Did I see that?
No,
We didn't put that in. Did we put that in at Connect Health? No.
I think we discussed it, but we didn't have the ability to do that. It's not like I don't think it reaches that level.
Yeah.
Did you decide whether you wanted to attach C, the May 5th letter, or just incorporate it by reference
Can
on
we
file?
make- Can we make that? What do you guys think? I would want to read it to make sure.
a file and the board based its decision on it.
Maybe you
It's in the
just
file.
reference it as
Say
a
it's
condition.
the decision's based on the applicants submissions, which is in
Yeah,
the. in the beginning.
Submission, but maybe specifically this. If that's.
It would
it's
be up
based on
higher.
All of it, but
Nikki.
yeah.
It is based on all of it.
it's based
It'd be
on
up in
all-
the finding paragraph.
Okay. I don't know. What do you guys think?
As exhibit C,
Huh?
as exhibit C.
I don't know that we need to. I think it's in the application, so I think it's probably. Like it's.
Madam Chair, you can reference it and say it's on file and just reference what that is that's
Yeah.
on file. In the founding paragraph that says based upon the following, which I believe is the next paragraph down. You can't see it from here.
Wasn't that implied? I mean, it's based on.
It's based on the materials in your second paragraph too.
Yeah, our decision is based upon the application and accompanying materials and representation testimony. We could say specific, if you want to call it out, you can call out the May 5th.
All of your decisions are based on the applications and the
Yeah.
materials, and I
Like
don't
it's,
find them
It's redundant.
incorporated in the past
Yeah,
decisions
yeah.
that I've
No, it just
authored or
Yeah, yeah.
recorded.
Well, I don't want it to also just limit it. Okay, I don't
Thank
think we need.
Okay.
What do you think?
Fine.
Yeah, we have to go.
Yeah.
Ms. Sheriff for typing.
I think Michael's up there still too, wasn't he on it? I
Yes.
think it was Jim, you, Lisa.
Yes.
Lisa.
I was there.
Michael, do you have any comments on this?
No, I read the proposed decision and thought it was pretty good. I agree that the construction techniques, the drilling, and instead of maybe we have something in that the vibratory hammer was not allowed, and leave it at that.
We do,
That's in
we have
five,
that.
Right?
Yeah, it's in there.
Well, that's in the May 5th letter.
Yeah,
It's in the
Okay.
one I got, 2 days ago I got it.
yeah,
Yeah.
okay. All right.
Number 5.
Okay, so, and does anyone, if there are no further questions or comments, anyone in the, do you want to, do you have anything to say about this one? Are you here for this one? Yeah.
Did you close the public hearing now?
Yeah.
Oh, sorry. Oh my God, long day, I'm sorry. Okay, so does someone want to make a motion if there's no more questions or comments?
I'll make that motion.
Oh,
Mr. O'Mara just made the motion.
Yeah.
okay. Would someone second it?
I'll second it.
Okay, so Michael made the motion, Lisa seconded. I don't have, did you text me who was sitting on this one, or was that?
It's on the signature page.
It's, I think, Jim, you, me, Lisa,
Thank
and Michael.
you.
It's Susan, Lisa, Michael, Elisa, and Jim.
So I'll do roll call. Myself, I, Lisa,
Nay.
Elisa.
No.
Oh, wait, we've already, no.
Wait a
What are
minute,
we doing?
guys.
We've already voted this.
Yes.
Did it?
But we're,
No,
Sorry.
we didn't vote to approve the,
the,
no.
We After
voted to
all
approve
this?
The public hearing.
Right.
That's it.
And so,
That was it.
After all this, we're going to deny it?
This is on the conditions, not
this
on
is
the
just
approval.
conditions.
So we didn't approve this project though.
Oh, boy.
No, we voted to approve this.
No, we didn't. We
We've-
voted
you
to
voted
close the
to
public
close it.
hearing and get a draft decision
And discuss.
and discuss the decision. We never voted on the decision.
right.
Can I
That's
ask
what we were
why it's
doing
being
today.
denied then? Because it has to have a denial.
It hasn't
I
been denied
didn't
yet.
vote aye.
It can't be just deny.
A point of order, Madam Chair, could you please call the roll vote again?
Well, hold on, I just want to look at the, when did we vote on this last month?
April 13.
It was just to close the public hearing.
Yeah, hold on, I just want to make sure. Motion to close the public hearing, motion to have a draft decision with conditions to review at the May 11th meeting. So O'Mara says, I thinks the board can make an approval subject to the approval of conditions that don't currently exist because we have to go back and review all the documents submitted. Leslie said it's an option to vote to approve a project, close the public hearing, and draft a decision for just the board to review and comment on at the next meeting. Closing the public hearing closes down any new public comments and new information from being submitted. And then Sarah Alger said, do you know when your action deadline is? And I said June 22nd. So we did a motion to close the public hearing and the motion to have a draft decision with conditions to review at the May 11th hearing.
Right. We
And
didn't
it carried
approve.
unanimously.
We didn't approve the public, we closed the public hearing. We didn't vote on the project.
Right.
What was the motion?
The motion was to close the public hearing.
Was it so moved after Ms. Snell made her
No.
comment to the board?
It doesn't say.
Well, you motion to write a decision with the conditions
Yeah,
in
we
it.
may have to go to the videotape on this one, guys, because I think I thought we were voting, I personally thought we were voting to approve it and then talk.
No, no, I did
But I
not.
see what you're saying in the meeting. but
I think we clearly, I remember saying, I'm happy to close the public hearing.
Mhm.
I'm not gonna make a decision on this until, the decision is written.
I think.
That's what you guys wanted to
That's
do.
not in the
That
minutes.
doesn't-
And this, what does this need to carry?
4.
4?
4 votes, yeah.
We
I
haven't
think-
adopted
I
the.
think
other one.
Lisa's correct. Because I tried to get to shut it down and approve subject to the conditions, and it didn't go through.
Okay, that part of the discussion is not in the minutes. So we should do.
Madam Chair,
Yeah.
may I ask through you if there are additional conditions that the board wants to see, or at least from the initial partial roll call that
Wait, I'm
the
sorry.
two nay votes would
Oh,
want
yeah.
to see?
Well, I think my concern is solely the construction of the basement. And I know you'll say that's not part of this board. It's only the 11 square feet that you're voting on. But I think anytime that you come to the board, it opens up the discussion about other aspects of it. And I'm uncomfortable with that, with putting a basement under this building, given the site conditions.
Most of the basement is outside of your jurisdiction.
I understand that, but you are in front of us. Take the 11 feet out of the equation. You can do whatever you want.
We can take the 11 square feet of the basement out of the equation. It can go
No,
on slab.
you're raising the roof in the setback, so you have to come to the zoning board of appeals.
Right, I understand that.
So
But if
don't
you're
raise the roof in
concerned-
a setback and put in your basement.
If you're concerned about the basement, we can take the basement out of that one tiny little corner.
No, I'm
doesn't-
no. I'm
that
concerned about the
doesn't- no.
basement around the entire property.
I understand that, but only that corner is within your jurisdiction.
No,
No.
I disagree with that.
Once you come before us, it opens up for a review.
It does, but that every single other section of this structure is conforming to zoning.
I agree with that. All I'm saying is do not raise the roof in that 11 square foot area, and you can put your basement under the whole thing because you don't have to come in front of the board. And you don't need my approval.
Well, you'll have to wait a minute while I call her.
I gotta go.
No, yeah.
We have to
No.
continue
We
it.
have to leave. We have to leave. So I think we have to.
I'm sorry, Madam Chair, could I please ask if you're voting on these conditions? I don't know that the board is clear on what you opened a roll call vote on, which was never concluded. So I just asked a drawback, like I said, as a point of order. I don't think your board members know what you're voting on. Some thought they were voting on the conditions. I think Mr. O'Mara said they were voting on an approval subject to conditions, and somebody's memory said no. I do recall directly from Ms. Botticelli that she had no concern about the 11 approximate square feet of the roof going up approximately 1 foot. So if your concern, which seems to keep going back to a basement, is it the construction methodology, or is it which would be the conditions that we've spent a fair amount of time over the last month working on?
To continue this, unfortunately, because
Just
we
to
are
be
now.
clear,
we are
Michael,
not- Yep.
just to be clear, that's not exactly what O'Mara said. I tried to get the board to approve the application subject to the conditions, which we'd get at the following meeting today.
I agree.
Lisa was against it. The board did not vote for it.
Which is what I thought you said, which is we're here to discuss the
The
conditions.
That's
that are
correct.
before you that we've
Didn't-
just spent
didn't
time
vote-
editing
Vote to approve or disapprove.
the conditions.
Chrissy can't hear, by the
application.
way. She just texted me. She can't hear anymore, so she has to be
So we
continued.
have to continue because we have a hard stop.
Yeah.
So I apologize, but we have to continue. So
But I
motion,
think we should, okay. Motion to continue.
because we can't figure this out
Second.
and we're already 10 minutes
minutes
over and
beyond.
we're gonna get in trouble.
Second,
So motion to continue until the next regularly scheduled meeting, which is June 11th, I think. June 8th. Well,
Second.
all right, who made the motion? Me, I guess. I'll make the motion. Jim seconded. Me, Lisa, to continue.
Oh, well, yeah, I.
Elisa, Mike,
I,
and Jim.
Aye.
Okay, we'll continue this discussion. We'll.
Thank you, Madam Chair.
Oh, yeah, motion. to adjourn.
Second the motion to adjourn.
Okay. Aye.
You want me to help you carry this?
Date on your.
John Brescher, aye.
Guys, motion to adjourn, Lisa.
Aye.
Elisa.
Second. Aye. Oh, second, whatever.
Thank you. Sorry, guys. Sorry, Nikki. Sorry, Billy. Why were we a hard stop? Because of the TV?
Yes.